Yes. Leave to mention contempt application for inclusion in the list. Great.
Motion matters, just hand over the slip. Appellate side, motion matters, just hand over the slip.
Extreme compelling circumstances.
Wait, sir, wait.
One
Motion matters, just hand over the slip.
Yes, I have one non-prosecution, lot of irrespective.
One after another. The motion matters. Any other motion matters? Motion matters. Yes.
Under extreme compelling circumstances, upon notice, I'm mentioning, this is in respect of a sand mining lease, which has been suspended. And it has been suspended admittedly without following the due process of law. My lease tenure is going to expire on.
Admitted means it is your admission.
I'll show from the document.
It is your contents.
Yes, I'll show from the document. I'll prima facie cases is there, my lord. But I am losing out on money every day, my lord. More than 1 month has gone, my lord. I am unable to excavate. December 2025 is the last date, my lord. I'm only.
December 2025 is the last date for what?
Expiry of the lease. So, my lord, if I do not enter, my lord, and carry on the work, my lord, I'll be losing money every day. Your
What is the prayer?
My lord, my prayer is for, my lord, the removal of the suspension, my lord, quashing of the suspension order.
For the timing, why you're mentioning? Upgradation?
Yes, my lord, upgradation, my lord. Otherwise, my lord, I'll be nowhere. Lord, I have served, my lord, on notice. Any day, your lordship.
Next day, under the heading fixed motion. Yes.
Non-prosecution. Non-prosecution.
Under the heading fixed motion. Wait, sir, wait. Tight আছে তো টাইটা বার করুন না sir, don't leave the court. Wait.
Mm-hmm.
28th মানে হচ্ছে Thursday. 28th August, Thursday. Give a fresh notice. Yes, sir.
Non-prosecution.
এটা দিয়ে দাও for non-prosecution নিয়ে নিন.
Milord, I filed an application for extension of stay order, which will expire in the August month.
Yes, extension of interim order give this week.
The matter is already in the listing. So only application is filed.
It is under the heading
adjourn motion.
Adjourn motion. Extension of interim order নিয়ে আসুন দেখে নিচ্ছি.
May be permitted, my lord, to mention an extremely urgent matter, my lord. What happened, my lord? The land belongs to me, my lord. The state of West Bengal has issued a tender, my lord, for extraction of blackstone, my lord, from my land. My lord, my name has been recorded, my lord, in the record.
Fixed motion under the heading.
My lord, 27th is the last date, my lord, for putting the tender. My lord, if third party right is created any day, my lord, prior.
28th August.
My lord, subject to lordship kindly was mentioning a very urgent motion. There is an existing mining lease. It is pending before this honorable court. Requisition is pending with regard to my chief mining officer has rejected my mining plan. That has been challenged and the requisition is pending. Now, during pending of the requisition, I had tried to, there are waste material, waste gravel. I wanted to take that out for commercial purposes. Now, for that, I need a road challan. Now, I paid before them. They said, right now, we cannot, we are not issuing that. We have more than 1,200 contractors and workers. Any day, kindly takes us. The only thing I will pay for lordship is to relation upon the respondent office, the BLRO, to issue a road challan so that we can carry out the, take out the wastage material that is there over the years. That is my only prayer, my lord. Now,
are you excavating beyond your area?
No.
Then?
No, chief mining officer, I had made an application for the environmental clearance. For that, I need a mining plan. That mining plan was rejected by the chief mining officer and saying that you need certain corrections and there are some oppositions from the private respondent.
So lease deed has not yet been executed.
It has been executed and it is a long-term mining lease. It is existing.
No, prior to the issuance of existing.
Yes.
Listen to me, sir. Prior to the issuance of the prior to the execution of the lease deed, mining plan has to be placed.
No, this is a lease of executed in the year 1920 for a period of 999 years. Now, after the West Bengal Estate Acquisition Act, we entered into an agreement with the state of West Bengal. So that is there. Now, in 2017, they said that in terms of the honorable NGT order, you have to obtain the environmental clearance. I said, very good, we'll obtain.
So without obtaining environmental clearance, how do you expect?
I'm not excavating. These are on the ground. these are the waste materials that has been accumulated over there over the years.
I shall
Only
see.
thing, my lordship,
I
kindly,
shall see.
otherwise, my lord, thousands of workers are not, they are not being paid. Only thing,
I
any day,
understand,
only
but I
thing-
shall see, sir.
Sir, I have noticed any day, lordship, kindly, sir, won't take more than 15 minutes.
Give
sir.
the receipt, we shall
But
consider.
any
It.
day, any day, any day.
Right now, I cannot pronounce the date.
Then, my lord,
Announce the date.
I'll come back day after tomorrow again once again. Kindly, any day, my lord, otherwise.
Give it to you, I shall see. এটা নিয়ে বিকেলবেলা একবার আমার কাছে আসবেন, আমি দেখে নেবো।
My lord, may I have to mention one matter. My lord, I have already mentioned 2 times. My lord allowed that. My lord, the coordinate bench directed to matter to appear as for orders. That's why I mentioned before your lordship, because of the mathematical calculation is already wrong of this.
What I am to do?
My lord,
Release the matter.
no. My lord, let it appear any day. My lord, earlier occasion, my lord allowed this prayer, but matter not coming into the.
What I am to do, sir?
My lord, let it appear in the any day.
Under which hearing? Motion.
For us, because coordinate bench directed to matter to appear for us because of the motion stage. My lord,
Coordinate bench passed an order, that is after hearing.
after
I am to hear afresh.
yes. Motion
How do I know what argument you have advanced before the coordinate bench?
yes, one.
So I'm to hear it afresh. So wait for your turn. No urgency, sir.
May I be permitted to
My lord,
mention,
No urgency, sir. I'm to hear it.
may I be permitted to mention item number 85, your lordship's list, hearing matter. Earlier I have mentioned the matter, your lordship was pleased to give me direction, my lord. After my lord circuit, my lord, I have to mention because
Hearing matters.
85, urgency is that, my lord, February 2026 is the date fixed for retirement of the employee. I am challenging the disciplinary proceedings without providing me any document, without anything, my lord. Now, my
85 I can reach, I believe.
any day, my lord.
85 I cannot reach.
No. We have urgency, my lord. If any date is fixed, my lord, in the matter.
2 PM কিছু দেখো তো আছে কিনা? এই week এবার next week এই weekই দেখে নাও কোনো 2 PM
Well,
কিছু আছে?
after second, my lord, because my lord, Mr. Bikash Ranjan Marjan, a senior advocate, is leading me in the matter. I am informed that after
Sir,
second
I can
day-
fix a date with as per my diary. It is now your headache whether we will come or not. 4 তারিখে ফাঁকা আছে। 4th of September. 4th September at 2 PM.
Obliged,
Mark করে রাখো।
obliged, my lord. I shall give notice also.
Lordship, may I be permitted to mention one matter, my lord, which has been erroneously filed under Group 1 instead of Group 5, my lord. Therefore, my lord's order,
Release is required. এটা আগামীকাল to be mentioned নিয়ে আসো।
I am grateful to your lordship.
My lord, I am paying leave, my lord, from your lordship.
Wait.
My lord, may I be permitted to for leave to correct the group of the writ petition, my lord. The writ petition has been filed in group 5 wrongly, my lord.
এটাও নিয়ে নাও, to be mentioned tomorrow.
Your lordship,
Wait.
my lord, I am paying leave before your lordship, my lord, the additional district magistrate, my lord, under section 54, appeal has been decided, my lord, and fixed for final order on 19/9/2025 as a for orders, my lord, without hearing my written objection. I was a party in the proceedings pending before the BLLRO. I am residing at now Gujarat. When, my lord, I came to know that appeal has been preferred against me without implement me a party, my lord, immediately.
Order has not yet been passed.
My lord, final
Give
order.
the
already,
opportunity
my
is
lord.
there. Approach the
There
appellate
is not, my
authority.
lord, written objection, my lord. I filed immediately on 11/8/2025.
Very good.
That was
After
rejected.
let
My
him
lord,
pass.
19/9 is the date.
No urgency,
my lord.
madam. No urgency.
There is a, my lord, promoters, my lord, if they, my
That
lord,
has been no urgency. Yes.
my lord, then, my lord, I filed.
I need
even-
appropriate manner.
Lord, kindly may I be permitted to mention this matter for upgradation. The matter is that we have 342 in the monthly combined list dated 4th August 2025. My lord, what has happened?
Hearing matter. Hearing matter.
New motion.
What is the urgency?
Since due to excavation made in adjacent land by the eastern coalfield, my entire property has been damaged.
Wait for some time.
That damage is
No
continuing
urgency,
day
sir.
by day, my lord.
Yes, madam.
Your lordship, kindly craving for leave to allow me to file this matter by today and fix the date of hearing on 27th
No,
August.
file it then mention.
Sir, there is a urgency basis.
I will consider the urgency. You file it in a
The
regular.
PLRO has issued,
Yes, Madam Sannal. What have you?
sir,
Wait,
It's a
wait.
reiteration of
28
matter I
December,
raised
they are
Whatever
going to
may-
dispose me.
My lord, this matter
Your
had raised
lordship.
before your lordship left, my lord, and your lordship had given me the permission to mention it again. My lord, the interim order is due to expire at the end of this month. However, my lord, if your lordship kindly fixes either on 27th or 28th, it's a very short application, my lord, it can be disposed of.
Application for what, madam?
My lord, it is a recalling application. So it can be disposed of. My lord, since
It will come under the hearing application or extension of interim order.
my lord, if you
I can dispose of the application in the under the heading. The extension of interim order. Yes.
on 27 because my lord, Mr. Banerjee will be leading me. So
Very good.
Your
Please,
lordship,
27.
the BLRO is
I
going.
told you, you file it thereafter.
There is an urgent basis. The BLRO is going to disposes me from my dwelling house on 28th December. Your lordship,
In which proceeding?
in a there is no proceeding. This is a that's why I am praying for
Which
a
order
leave
is under
application.
challenge? Which order is under challenge?
The order of BLRO, the issuance of notice of BLRO. The BLRO has issued a notice to dispose me on 28th December from my dwelling house, your lordship. The
file
matter
with
is
you.
pending.
File is with you.
Yes, file is with me.
Show me the impugned order. Show me the impugned order.
The matter is under sub judice in civil court, your lordship.
No, there must be a direction of the LRTT.
No, there is no direction to dispose me from any of the forum like LRTT or
What order has been passed by the LRTT?
LRTT has passed an order to direct the ADM DLRO to adjudicate upon the scenario, but no order has mentioned to dispose me from my dwelling house. Neither LRTT nor the civil judge nor any of the forum direct me to dispose of from my dwelling house.
Leave the
Lord, may I be permitted?
27th August, they are going to dispose me on 28th August. Please fix the date on 27th August for hearing.
August 27. Under the hearing.
Grateful.
Fixed motion.
My lord, may I be permitted to mention one matter, my lord? It's a fresh contempt application, my lord. Let it be listed. Grateful.
Contempt, where is the contempt application? Contempt application already filed.
Yes, my lord.
এটা বলছে ফাইল হয়েছে দেখে নিন আনিন
8th August it has been filed.
Yes, Mr. Mukherjee.
My lord, may I be permitted to mention, my lord, this matter, my lord, pertaining to a notice issued by the highway authorities as well as PWD, my lord, for disposing us, my lord, without giving any sort of hearing or anything, without any even prior notice. They are just affixing in a place, and my lord, I need, my lord, kindly, my lord, fixes any date, my lord. Any date, my lord.
What is the date fixed?
My lord, date fixes, my lord, 28th. Otherwise, I would not have mentioned, my lord. Any date, my lord, as your lordship.
28 রাখো
My lord.
We have
Deeply
lordship,
obliged, my
kindly,
lord.
my lord.
28 तारीख है।
We have lordship,
Deeply obliged, my lord.
kindly, my lord, from precedence, my lord, the same issues, my lord, where the, my lord, state highways authority and, my lord, the PWD, my lord, they are, my lord, evicting from my, lord, the.
If I find though no merit, it will be
My lord,
dismissed with
that's right,
cost.
my lord, this matter is appearing.
Both in your case and in Mr.
Yes, my lord,
Bhattacharya's case.
same, my lord.
If
your
it is
lordship-
found
if your
that it is a
Yes,
unfounded,
My lord, then
it
my
will
lord,
be dismissed
I will be
with
ousted. I will be
acceptance
ousted.
cost
my
be
lord.
correct
My
assured.
lord, my lord. 3 matters are there, my lord. On the same day.
3 matters.
Yes, same. For 3 shop rooms, they are going to evict, my lord, on that basis.
You must be an unlawful encroacher.
My lord, that your lordship is aware of the, my lord, the right to fair compensation. My lord, that tax is there. So, my lord, 20 years we are
Very
there.
good.
We are paying.
Yeah, I will hear it.
My
But if it is found that your application is vexatious,
my
get yourself
my
ready
lord.
for getting
My lord,
exemplary cost.
my lord, my lord.
Per petitioner 10 lakhs.
My lord.
Yes.
My lord, may I be permitted to mention one matter for inclusion, my lord? Your lordship has been pleased to fix one analogous matter, my lord, that has been filed by.
Wait for some time.
My lord, if that matter is heard separately, my lord, I will be prejudiced, my lord.
Release.
No, my lord, that matter has been fixed before your lordship, my lord. And
When it is fixed?
it was fixed on, it was to appear on 19th, my lord. Now it will,
On that day or mention?
my lord, only, my lord, this matter to appear with that matter, my lord. Only this prayer, my lord. Nothing else, my lord. So that, my,
Under the heading hearing.
my lord.
নিয়ে নিবে ফিক্স মোশনে নিয়ে নিবে ওই 27-28 বললেন না 28 এ দাও এটা উকিল ও কি বলছে দেখো এটা দেখে নি এটা কি বলছেন একটা মার্ডারের সঙ্গে অ্যাপিয়ার করার কথা ও তারপরে ওটা দেখো উইথ কিছু করবে না
My lord, it was not to appear with that matter. I'm praying for that, my lord, so that it appears with that matter. I'm so grateful, my lord.
We have a lordship, my lord. New motion, my lord.
My lord.
Permit to mention my lord, new motion inclusion, my lord,
My lord, I am mentioning a matter, my lord. This is an application for restoration which was dismissed for default on.
give restoration application
My lord, I beg.
PWD has already issued the demolition order, my lord. The demolition will be on 20.
let them demolish I shall consider
My
let
lord,
them demolish give the slip yes Mr. Mukherjee very good
What happened, without following the procedure 10-1, your lordship already passed an order in my matter. State has produced the record saying that my lord proceeding.
give me এটা নিয়ে নিন না মোশনে বলছি তো চলে আসবে
on inclusion, new motion.
yes
But I have specifically pleaded no proceeding 10-1. Your lordship knows 10-1 proceeding. If I lose, I have a remedy 10-3 appeal. Nothing has been straightaway demolition order. Your lordship has already entertained my lord fix one matter on 27, my lord. If this be appear on 27.
27 give me
My lord, I beg to mention one matter for inclusion, my lord, new motion.
My lord, after filing the suit, it is still pending. Not at single time is updated for hearing. My lord, kindly mention taken up the matter. My lord.
is a motion stage
Yeah, motion state. New motion. With you.
I beg to appeal for the petitioner, my lord. This is a notice, my lord, to all the parties. This
who is for the state
My lord, I am appearing on behalf of private respondents number 9 and 10. We have been served with the notice on Friday. And I am appearing under instructions from the client. I shall file the wakalat now.
what is the affidavit of service
the evidence means the original side, my lord, we post it and then we get the number. There is a evidence service already on record. In the original side, we have to post it first, then we can file the matter. Advance notice. Well, I given by mail as well. That is why.
give me a second where from we'll get the track report then
You know, track reports, that's we have put it on mail. This is the new rule of the original side, my lord, that we have to file the postal receipts only, then we get the number.
এই তোমাদের এখানে ট্র্যাক রিপোর্টে তাহলে কি হবে আসবো দরকার নেই হ্যাঁ না আমি তো পোস্টাল রিসিপ্টটা পাঠিয়েছি ইটস অল রাইট কিন্তু সেটা সার্ভিস হলো কিনা বুঝবো কি করে
The private respondent has received the, my lord, the post. All our statutory authorities, my statutory authorities email has been there, my lord. All our statutory authorities.
you have not taken out the track report also
My lord, this has been filed before the matter was filed. Along with the matter, my lord, this has been filed.
I understand sir
Well,
you
today
don't
morning,
have
my lord,
any you
today
don't
morning I
you
could
don't
not do
give
it.
the copies
Well, today morning I could not get it. The service is not working. I could not get it. Like email, because what we can do is only the emails, my lord, we can do. Well, how will I make another video service?
no from the website of the postal
It's not working today morning.
yesterday what was
I checked it till yesterday. I could not find anything.
today morning it's not working. Today morning he came at 8:30. We tried. My lord, that is why you put on mail is a good service, my lord. No, statutory authority.
Whether the mail details are correct or no, how do I know? That is
So
the
these
whole
are
difficulty.
these are on the websites. These are government bodies, my lord. Well, I have prepared another affidavit service, my lord. I could not affirm it. The affirmation did not open as of yet.
May
And
I see
affirmating
the
the-
affidavit of service?
This is through mail. This is through mail. It's on affidavit itself.
Who is the advocate on record of the?
Mr. Parutoshi, na? Well, his clerk has been informed. I have WhatsApped him, my lord. It's all there. My lord, what I seek today, my lord, are not the disposal of the entire writ petition, my lord. Only
Give me a second.
only one line stay.
Give me a second. Yes, sir.
My lord, the writ petitioners, well, there are two sets of land. Two sets. My lord, A and B. My lord, A consists of A is the, my lord, the essay, that is the secured asset, which has been given by the private respondent to the bank as a secured. My lord, he has to the bank as a secured creditor. My lord, this property was mortgaged to the bank. That is all right. My lord, that is, I'll just indicate.
You for the?
And for the state, your lordship, this matter probably cannot be taken in ordinal side.
Oh, I was hoping this, my lord, this would come.
No.
My lord, kindly have a look at rule 5 of the writ rules.
Your lordship,
This is
before
maintainable.
that, let me place mine. Why it cannot be taken in ordinal side, then my learned friend will place. Lordship, this is the rules of the Calcutta High Court in ordinal side, in the ordinal side rules. Kindly see rule 1 and 2, and then kindly come to the parties and the prayers. First one, your lordship, deals with mandamus, where a prayer of mandamus is made, and the second one, probably, your lordship, I have only one copy, certiorari.
You are referring 1 and 2?
Yes, yes.
Give me a second.
কি হয়েছে তুমি ডাব্লিউপি করে করে দাও না করবে না
এটা
তো
হয়ে যাবে রুল 5 এ বেরিয়ে যাবে আমার আজকে একটা ম্যাটার আছে এর মাধ্যমে এই কথাটা ক্লাসেস মানতে শুনলো না
After 1 and 2, which one you are referring?
Your lordship, 1 and 2 now kindly comes to the writ ones. Now to the writ petition.
Yes.
Kindly comes to the parties, your lordship, the respondents. Lordship, the first is outside the jurisdiction, original side jurisdiction. The first
Principal Secretary.
Yes, Nobanno,
No.
outside the original side jurisdiction. The second one, DM South 24 Pargana, outside the original side jurisdiction. The third, South 24 Parganas, outside the original side jurisdiction. Fourth, Gram Panchayat, outside the original side jurisdiction. Fifth, probably is inside original side. Sixth, inside. Seventh, inside. Eighth, again or outside the jurisdiction. Now kindly come to the prayers, your lordship. Prayer at page 24.
Yes.
A is certiorari, B is mandamus. Now comes to C. That is the most important prayer. C, he wants to touch upon a land which is outside the original side jurisdiction. Your lordship knows, the moment I want to touch upon any land, it has to be in the original side. This is not in the original side jurisdiction, your lordship. So nothing else. It has to be transferred to appellate side and the matter can be heard out.
This cannot, I say why it cannot be done so. Will kindly take rule 4, rule 5, my lord. Kindly have a look at rule 5 of the writ rules. This is the দাদা এটা মামলার সাথে দুটোর সময় আছে জাস্টিস মানতে নিলেন না I have a similar matter at 2 o'clock where all
Give me a second, sir.
নিয়ে এসো না তারা থেকে দৌড়ে
How 5 is helpful to you?
5, my lord, is this, may I just have a look, my lord? I have the online copy. May I have a look at the book once, my lord? I'll just indicate. Prayer for certiorari, my lord? My lord, all applications for in the writ of the nature of certiorari, wherein the records are located or are available within the original site, original civil jurisdiction of this High Court, whether relate to an authority or a court, exercising, will kindly have a look at prayer A and respond number 7's address. Have a look at prayer A. Whether relate to an authority or a court exercising civil, criminal, or otherwise jurisdiction shall be dealt in the original site and likewise be marked as original site. Marked in the original. This is what we do. I have another matter. Mandamus is number 4. Rule 4 and Rule 5 are anyone if they hit in Rule 4 or Rule 5, will mark in the original site. We do not mark it in the original site. There is a scrutiny that goes on before filing in the original site. Pass that scrutiny.
Land is outside the jurisdiction.
Might be land is not in question, my lord. The authority, the act of the respondent number 7 is in question, my lord. The act of the respondent number 7. But this is not a civil court.
Kindly say prayer C. He's asking mandamus.
Well, I might ask for mandamus if my prayer is a certiorari. But when there is a certiorari, it has to be marked in the original site. Well, I have a matter at 2 o'clock, same situation.
Let him place a judgment. I have a judgment to my effect. I can place it passed by the coordinate bench of this High Court, whereby similar issue was conducted.
No, your main relief is the mandamus.
Against the respondent, well, mandamus is always there. My main relief is not. Whenever there is a prayer for certiorari, it can be maintained in the original. I have matters in the division bench, today afternoon, my lord. But this point was raised by me. It was cut down by my lord Justice Mantha. Whenever there is a prayer for certiorari and the records relates to where it is placed in the original site, it has to be taken up in the original site.
Kindly see your lordship, Rule 4 and Rule 5.
Rule 4 and Rule 5
Rule 4 mandamus, Rule 5 certiorari.
If there is a certiorari, it also be marked, likewise be marked in the original site. It is likewise, my lord. Kindly have a look at the language in prayer 4, my lord, the Rule 4, Rule 5, my lord.
So all the records are lying with whom?
With the respondent number 7. They are the authorized officer of the bank.
Who is the mortgagee?
Mortgagee.
Very good. Place your application.
Kindly have a look, my lord. This state has nothing to say at this moment, my lord. But state has done nothing wrong, my lord. What has happened, my lord? I have mortgaged my land. The respondent number 9 and 10 has mortgaged their land to the bank. The bank, they failed to pay. The bank wanted to take the possession of the assets. There is no problem with that. The A set of assets were given to the bank. I am the owner of the B set of assets. I'll just indicate, my lord, how.
Is there any schedule to the writ petition?
No, my lord. There is no schedule to the writ petition. I'll indicate, my lord. There is a schedule to the order that is put on the challenge, my lord. There is a schedule to the order, my lord. কোথায় বাবু? না ওটা অর্ডারটা যেটা ডিএম এর প্লাস ইন্ডিকেট মিরর kindly comes to page 55, the schedule of the property that has been mortgaged. This order has been affixed at my premises. I'll indicate.
Page 55.
Page 55, my lord.
Yes.
There is the schedule of the property in the middle, my lord, at the paragraph above the bottom, my lord.
Yes.
My lord, kindly have, my lord, comes to first, second, third, and fourth line, my lord. LR DAG number 196, 195. This is one set of land.
Entire or a portion?
Portions. Certainly. আমার পেছনে Ms. Mouja is Dari Jagannathpur.
Yes.
Because this is 195 and 196, two properties.
Hmm.
This belongs to the my just
Land and two-story building with RCC roofing.
the land and
Telling
two-story
about
building.
26.4.
Kindly note the two-story building. That is important. Kindly note it once. Two-story building on 195 and 196. This is the what the bank has. What the bank can take the possession of.
Measuring about 26.41 soto.
Whatever maybe. One plot number 195, 196, and two-story building, and which the private respondents will not have mortgage to the bank.
Yes.
What I am an owner of. Kindly have a look, Milord. Comes to Milord. The annexure, Milord, the plan. This is a sanctioned building.
Page number, sir. Page number.
35. At the corner, Milord. Right hand side corner.
You don't have the deed of conveyance.
This is the inherited property, Milord, coming from the pre-independence era. This is sanctioned plan in my name and also the record of rights. I'll show indicate.
Yes.
The proposed two-story building at the corner, Milord, at plot numbers 188 portion and 189. This is another set of land where there is a two-story building. So this is a two-story building plan
Proposed.
The proposed, this constructed.
It has been constructed.
Yes, it's constructed. Milord. It's too very old. Milord.
So it is at plot number 188.
188 and 189. And on two plots, adjoining plots. Milord, there is the I've taken my father has taken a loan. My husband, my deceased husband has taken a loan, and on the basis of that loan, Milord, they have constructed. Loan is repaid the loan. Milord, this is the kindly comes to page 50. This is this building was standing in the name of Milord Horipodo Haldar. The sanction plan in the name of Horipodo Haldar. Milord, my names will appear in 1, 2, and 3. 1, 2, and 4. This petitioner's
Horipodo Haldar is alive.
He's dead, Milord. There is the death certificate is also there. And the
page number
48, 49, death certificate, and Milord, the heirship certificate in page 50. Pritilata Haldar, petition number 1. Pushpal Haldar, petition number 2. Upal Haldar, petition number 3.
Page number 48 is the Horipodo Haldar death certificate.
50.
Page number 48.
Death certificate.
Page number 48 is the death certificate, I believe.
48 is the death certificate. This is the burning certificate. Cremation certificate 49 and 50. 50 is the Milord, the
legal heirship
certificate. The petition numbers 1, 2, and 3 is the three petitioners' name would appear. Well, currently, Milord, I am the co-owners of that plot 188 and 189, along with the respondent number 9, who is also my son. So we are not in talking terms, Milord, but still he's my son. He's getting a share, Milord. Brothers and son. 1/4 share he has that property. Page.
You have made Nilotpal as a performer.
Yes, Milord. He's the mortgager. It kindly comes to page 51. This is the photograph.
No, wait. Nilotpal is also your brother. Is also your co-sharer.
Yes, he's 1/4 co-sharer. That is not the secured asset. That
Moushumi Haldar is the wife of the Nilotpal.
Wife of Nilotpal.
He's the
guarantor. Co-borrower, guarantor, whatever, I don't know, Milord. What is he?
Be the resident.
Milord.
Then what happened?
Page 51. In page 51 is the photograph. Well, that is important. This is the photograph of the scheduled property 188 and 189. The building standing at 188 and 189. This is sanction plan which I have shown up.
That is your building.
That is my building. That is not the secured asset. Milord, see, we kindly have it at the bottom, Milord, the left-hand side bottom photograph, Milord. The notices has been affixed in my premises and I have been asked to vacate. This is the enlarged photograph, page 52.
Yes.
In the enlarged photograph, kindly have a look at the schedule. I don't know, my Lord will be able to see that. Well, I have a better copy on the next page. 52, a better copy. 53 and 54. Kindly have a look at the schedule. 196 and 195.
Those are not secured property.
195, 196 is secured property. But the building is standing at 188 and 189.
What is your averment to that effect?
There's averment. I'll show one more document. Will kindly have a look. Kindly have a look. Will kindly have a look at the surveyor's report. I've made the 2 properties surveyed, Milord.
Show me the, tell me the page there.
63, Milord. Sorry, Milord.
Are you in a hurry, Mr. Ganguly? I'm hearing you.
No, Milord. No. My bad. Page 63.
Yes, sir.
On LR Dag number 188 and 189, that is not the secured asset, which is not the secured asset. There is a G+1 storage building. Common passage Dag number 188, 189. They share some part of the temple, the part of cowshed, which is shown in green color in boundary line. The owner of the property is Pushpal Haldar, Upal Haldar, and all my names are written. On Dag 196 and 195, the next paragraph, that is a secured asset, which is in the name of Nilotpal Haldar. That is the respondent number 9. According to deed, he has purchased the property, Milord. According to deed number Ato, Dag number 195, 196, he bought total. What is there? In 195, it is used as pond with bank. And the rest may be used by Mr. HON'BLE Haldar and others, they are the co-sharers of that land. On 196, there is a statue of Mr. Horipada Haldar, that is our father, Milord. Some areas used as cowshed, and the rest of the land used as danga. There is no construction, there is no 2-story building on 195, 196. Well, my premises, there is a 2-story building on my land, but they are wanting to attach that. But I don't know what the game the respondent number 9 and 10 has played with the bank. That is unknown to me.
But in the schedule of the property, as has been executed which is the proceeding under section 14 of the Surface Act.
Yes. Well, there is 195,
it says it discloses that the land with 2-story building.
Land with 2-story building at 195 and 196.
But it does not reflect so.
No, there is no building. This is the fraud that they have committed.
So page number 63 is what?
This is the surveyor's report.
You're appointed by
my
you.
appointed surveyor's report.
Your appointed surveyor.
Yes, Milord. This is what I could do at this moment. Milord, this is a cultivable land. Well, how will there be a building in the cultivable land without a sanction? And not even with a sanction, Milord. If there is a building, Milord, this is contravenes section 4C of the LR Act. If there is no 2-story building, my 2-story building is next door, Milord, they want to attach that. How can this be done? Well, I am a 75 years old woman, Milord, bedridden. Well, my son's son is having my grandson is suffering from blood cancer. But they will be thrown out of the house. But I don't know, Milord, what the respondent number 9, they can say what the respondent number 9 and 10 has done, Milord. We have no link with we are not the borrower.
For the present, you want to stay on page number 55?
Yes, Milord.
Anything more?
I'll just check, Milord, once more. Next page.
What is your pleading to the effect that this building is not this is a different?
Paragraph number 20, Milord, at page 15. Paragraph number 20 at page 15.
20?
Yes, Milord.
Place.
Your petitioner submits that there is no 2-story building standing at all the piece and parcel of land. That is the schedule. There is no 2-story building at premises. The next page kindly turns over, Milord. RSLR Dag number 195, 196. This is a secured asset. There is no 2-story building, I have said.
No, I want to see where is your pleading that instead of the secured, serving the notice on the secured asset, it has been affixed at your premises.
Page 14, paragraph number 17. You petitioner says that neither the petitioner has given no objection to the private respondent 9 for obtaining any loan of the respondent number 6 in respect of said property, nor the property has been partitioned till date, and after the demise of Horipada Mondal, they still recorded in the name of Horipada Mondal and joint property held by the Milord. There is no circumstance respondent number 6.
I want to know.
I understand, Milord. I'm
where is your pleading to that effect? Please listen to us. First, listen. Where is your pleading to that effect that the bank authority has affixed the notice on your property? That I intend to see.
It kindly comes from paragraph number 10. If it states as surprising on last week in the month of July, few officials from the respondent 6 came to the residence of the petitioner and affixed a notice addressed to the private respondent 9 and 10. A copy of said notice is attached.
But a
The
few
petitioner
officers
states
of the respondent number 6 came to the residence and affixed a notice. Then a copy of it.
6 and 7 is the bank pillar.
So page 10 and 11 are relevant.
Yes, ma'am.
You do not go through the pleading before coming to
Today
the
morning,
court.
today morning, my lord, the
You have mentioned it in the circuit
I-
bench.
like-
I am to search out the pleading. Yes, sir. What have you got to say? Who is for the bank? You are for the private respondent.
For the private.
I believe you don't have nothing to say.
Your Lordship, the bank is trying to paint a tainted picture here. There is no land on my property,
Very
and
good,
if they
anyway,
find
anyway.
any land, they may encroach it.
Very good. Ashut. এটা ফেরত দিয়ে দাও Yes, call the list.
In this matter, I'm for the ST.
Why it is for forwarders, sir?
I don't know, Moira. First time I may appear in this matter.
Who is for the petitioner? Why it is under the heading forwarders? Coordinate bench or myself? Myself. Where is short? Give me a second. You are appearing on behalf of?
State matter. Led by Mr. Supriya Chattopadhyay.
So what prompted you not to appear on the earlier occasion?
I have received the brief on
We have missed the list. I'm confessing that because it has been handed over to in the month of May, but missed the list.
I have to send notice twice to your legal remembrance.
Yes, my lord. That is not informed by the legal remembrance, but today it has knowledge that it appeared.
Yes. What do you propose to do, sir? What do you propose to do?
My lord, kindly accommodate me for 7 days, my lord.
You intend to use objects affidavit in opposition?
I haven't.
You don't have the copy of the writ petition?
No, a copy has come.
Then what do you want to do?
No,
Today even you are not ready.
Yes, my lord. Sorry, my lord. না সেটা আমাকে দেখে নিতে হবে একটুখানি
On behalf of the respondent state, produce the report of the
সকাল আমি সন্ধ্যার দিকে তুমি কোন দিকে সকালে My lord, I am for the petitioner in item number 3 and Mr. Bose is for the petitioner in item number 2. I have come.
Robin Bine is your client. Mr. Basu's client.
Mr. Basu's client. And
Sondha Sardar is your client. Mr. Chatterjee's client. Yes. Give me a second. এই আরেকটা ফাইল কোথায় আছে বাবা? এখানে দাও।
ওদের মামলা। আমি
এটা রেসপন্ডেন্ট
এটা পল্লবদা
Yes, Mr. Basu.
Yes, the impugned order, my lord, is page 52.
Page number 52.
But this is I am challenging, and Mr. Chatterjee, my learned esteemed
I'm
friend,
seeking the implementation.
Mr. Chatterjee is seeking
implementation of this order, and I am seeking quashing of this order.
page number 52. Give me a second, sir.
আমিনি এবং সন্ধ্যা অথরিটি কই
My lord, East Kolkata Management Authority.
Give me a second, sir.
Retail order.
ভীষণ হতো একটা।
Who's for the state?
The authority is required, my lord, East Kolkata Development.
Because they are the competent respondent too.
They are required to be heard, no?
Yes,
Yes.
They are required.
They are the, which one is the answering respondent then?
East Kolkata Management Authority.
Respond number?
My lord.
In my petition, they are respondent.
No. Mr. Basu's petition.
My petition, respondent number, East Kolkata, কোথায় গেল? 4.
4 is the SP, sir.
4 is
Five,
Technical
five.
Officer, Department of East Kolkata. 5. Sorry.
Respond number 5 is the appropriate authority.
Yes.
Notice has been effected prior to that.
The service there.
Services.
Have they ever appeared? Mr. Shishanno Bandyopadhyay, Mr. A.K. Nag appeared for the state. Respondent, the East Kolkata Wetland Management Authority is an instrumentary to the state. Then the state is
But Milord is a salutary body. It was framed under Milord the East Kolkata Wetland Management Act 2006.
no. What I intend to know whether they are
Yes,
represented
separate
by a separate lawyer
Yes.
or they are
That is-
represented
that
by
is-
the
They must
state
have a
lawyer.
separate lawyer, man.
Because I do not know.
But state lawyers will be able to apprise your lordship that whether they have a separate.
But
But
Mr. Himadri Shekhar Chakraborty appeared.
they should have a separate lawyer, actually.
Ashun. The subject matter of
For the petition.
Who's for the state?
Although senior advocate was appearing before resigning from his post of state government panel lordship. The last person also wait for some time.
Devduti Dotto advocate for the state.
Supratim Laha was also appearing.
You are appearing.
Led by my lord, Mr. Dhar.
Where is Mr. Dhar?
Where is my lord? Code number 10, my lord.
Pass over.
Pass. Can I note that several adjournments were sought for?
Let me see.
Parties.
Pass over. Ask Mr. Dhar to come at 12:30. Call the next matter. কোথায়? Very good. উনি ওই কোর্ট চার্জে ছিলেন? That court was in charge. Very good. Then don't call fire. একবার call করুন. Call the next matter.
I am for the respondents number 6 and 7, Gas Authority of India Limited.
I am for the Union of India.
Who's for the petitioner, sir?
Mr.
Mr. Devanshu Bondhu.
Mr. Devanshu was there on the last occasion.
None appears on behalf of the petitioners. Why not responding, sir? What's your good name?
Watch.
Readings are complete.
Suppose grant me liberty to file an exception to the report. Due to the medical emergency, I could not come to the court for last 1 month. And the state was also directed to file an additional report.
By which order?
Order dated 9th of July.
Who's for the state?
Mr. Day was appearing.
Oh. The exception to the report is to be filed within 1 week. So from 9 July, 9 July means this 15 July. So 15 July onwards, you are not present in court.
Well, I was suffering from mumps. But earlier occasion, on 24th, my colleague prayed for an adjournment on that period.
Mr. Dev, where is your report? Have you served copy?
Yes, my lord.
No.
Hey, my lord, in the report, my lord, that is the service was there. Your lordship will see.
Very good. You still want to file exception?
My lord, because I have not received any copy, my lord. This is copy.
Very good. Ashun.
My lord,
Pursuant to
6, no. 7 I am.
But I'm appearing for the respondent number 6 and 7, Gas Authority of India Limited. But
Mr. Adok appeared with Mr. T.M. Siddiqui. Where is Mr. Adok? Mr. Adok was just here. He prayed for Passover. It is identical.
Same order.
Very good.
No report has been filed on the behalf of.
In identical, it will be governed but not the same.
Admitted in the petition.
It is submitted to the bar that the instead matter is identical with WPA 6686 of 2025, which is fixed on September 3, 2025. In view of such, let the matter be listed on. Mr. Adok, what is your report? You are so busy.
No, my lord. What has happened, my lord? This report is lying, my lord. Mr. Siddiqui files, my lord. Kindly, my lord, 2 days time, my lord. That's why, my lord, I
Very
call.
good. I'm fixing a date.
Call.
Let the matter be listed on September 3, 2025. Immediately after WPA 6684/2025 under the same heading, Mr. Adok is permitted to submit his report on the adjourned day. However, an advance copy of the same shall have to be served upon the learned advocate on record within 3 days from today. Stop para. Liberty is given to the writ petitioner to file exception to the said report of the state on the adjourned day. However, an advance copy of the same shall have to be served to the learned advocate for the state by August 29, 2025. Mr. Agad, Mr. Adok,
Definitely, that's why.
otherwise I will not accept your report and your exception.
My lord, kindly.
In this case, it is admitted. They have received.
I shall consider on that.
My lord, 8 already, my lord, dispose of this matter, my lord, previous. No, 8, my lord, court number 17, my lord, urgent determination of this, my lord, honorable court, my lord, that is already disposed of, my lord.
Very good. The order dispose of the key.
I'm for the private testimony number 10, my lord.
Which for the state?
Upon the state admitted.
This restriction is not at all maintainable, my lord.
May I submit?
Yes.
Let me see whether service has been affected or not.
GPR, first page, my lord.
All item dispatched.
Learned government Twitter has been served. First.
When notice was served?
First page.
15/5. হয়েছে এখনো আসেনি।
The private respondents are appearing and state is represented by the learned government Twitter.
Sir, why have not taken the latest track report?
Difficulty is, my lord, in the my lord, this period, my lord, there was an updation in the website of India Post, and after that, my lord, the previous records are not available. That is the difficulty with India Post. My lord, may I submit, my lord? Lord, in the return, my lord,
Give me a second, sir. Yes, make your submission.
My lord, pictures of the my lord, below belongs from the below poverty line scheduled caste. They are, my lord, long-standing, my lord. They are, my lord, residing, constructing, my lord, kacha house, my lord, in the, my lord, roadside, PWD roadside.
Encroaching PWD land.
On the PWD, my lord, roadside. My lord, instance of the private respondent, a writ petition was filed, whereby, my lord, an order was passed, and thereafter, my lord, the proceedings have been brought. My lord, while, my lord, deciding this proceeding, my lord, a notice has been under section 10(1) as of the, my lord, Highways Act 1964 has been, my lord, issued. We have challenged that notice. But, my lord, we say that, my lord.
Yes.
My lord, we say that.
So what is the illegality in the notice?
Yeah, may I come? That is, my lord, I am trying to, my lord, say, my lord. My lord, first, my lord, they filed the writ petition. There is something, my lord,
Yes, who are obstructing you?
Say that we are obstructing. They are ingress and egress. My lord, the report of the BLRO has not been served to us. Whether the report says that we are, my lord, obstructing the ingress or egress, that has not been made over to us. As per our instruction, my lord, we are not obstructing anyone's, my lord, ingress and egress, and not even to the, my lord, PWD authority is not, my lord.
So avail the opportunity of 10(3).
We have challenged this notice because, my lord, if we accept, my lord, 10(1), then 10(3) is the consequence. My lord, may I submit that we are, my lord, residing there for a long period, not less than 40 years. And the petitioners, my lord, are the subject to correction, my lord. They are the purchasers of the land, my lord. After the land where, my lord, we are residing. Last 40 years, my lord, we are residing. We are landless people, and, my lord, we are landless people, belongs from the below poverty line and belong to scheduled caste. My lord knows, my lord, there is a limitation under section 112. First, my lord, at the instance of the private party, if we, my lord, block the ingress and egress, that has to be ascertained. That report has not been, my lord. The order does not reflect. Notice does not reflect. So it reflects only that we have encroached upon the PWD land. That is why, my lord, 10(1) notice has been issued. Whether at the instance of the private respondent, they are utilizing the state machinery.
The state report is required.
And, my lord,
have you
inquiry report is in my hand, my lord.
Give it.
Lord, the proceeding is already initiated, my lord. After 10(1), 10(2) proceeding is already initiated.
No, they have participated in the inquiry proceeding.
Yes. Very much.
But we have not been given to the report.
Very much participated. And
we have not been served with the report. Whether
After
the
that,
report, my lord, indicates that we are blocking the ingress or egress.
yes, specifically it was submitted, my lord, in each pages. My lord, the paragraph.
Have they participated in the
my lord,
demarcation process?
My lord, all the petitioners have participated in the demarcation process, my lord, by putting their signature. My lord, kindly come to paragraph 3 of the report. Paragraph 3 of the report. তদন্ত প্রতিবেদনের সহিত স্কেচ ম্যাপ ব্যক্ত করে দেখা যায় যে নীল চিহ্নিত অংশে বনবাস পালে দক্ষিণে পিডব্লিউডি অধিকৃত সরকারি জমির গোলাপি চিহ্নিত অংশে বিবাদী জয়দেব বিষয় বাসস্থান করে দখলে থেকে বাদী বনবাস পালে যাতায়াতের পথ অবরুদ্ধ করেছেন। দেন মাই লর্ড প্যারাগ্রাফ 4, 4 নম্বর বিবাদী জয়দেব বিষয় অন্যান্যগণ সরজমিনে উপস্থিত থেকে জানায় তাহারা ভূমিহীন ব্যক্তি হইতেছেন। অনুসন্ধান করে জানা গেল জয়দেব বিষয়ের পিতা মৃত বংশীহরি বিষয়ের নামে মহার 397 নম্বর মৌজায় 94 দাগে বাস্তু 4 শতক আছে। উত্তরাধিকারী সূত্রে উক্ত বাস্তু পাইবেন। উক্ত 8 নম্বর বিবাদী ভূমিহীন ব্যক্তি নন। Then, my lord, paragraph 5. Last two line, CA number such and such, my lord, রূপান্তর পাকা বাড়ি নির্মাণ করে বাসস্থান করে দখলে আছেন। স্কেচ ম্যাপে গোলাপি চিহ্নিত অংশে বাসস্থান করেছেন এবং পায়খানা ঘর করেছেন। আবেদনকারী প্রণবেশ দাসের যাতায়াত বন্ধ করেছেন। বিবাদী 8 নম্বর জয়তের বিষয় 5 নম্বর প্যারাগ্রাফ 5 নম্বর পায়খানা শোকপীঠের জন্য প্রণবেশ পালের জায়গা যাওয়ার পরিবেশ দূষণ হচ্ছে। Everything is quite clear, my lord. Hand sketch maybe is just 10 to notice was issued also already, my lord. Subsequent 10 to notice was issued.
Take down.
First paragraph.
May I, my lord, submit? But since the report has been handed over to us, my lord, just
Take this point in the 10 to 10 proceeding.
my lord, we
Before
may be
the-
granted liberty to challenge the report.
The read petitioner
Observation, my lord.
The parties are not today. Not today. Yes, call the customer 12:30 বলেছি. It's 12:20 only. After 10 minutes. Call the next matter. Not today.
Talks of settlement is going on with the parties match.
It is submitted on behalf of
I appear for I shall start in between. But in this matter, if you remember, on the last occasion, I have already filed one supplementary affidavit, and I have also served them with the copy of the supplementary affidavit. I shall.
Is item number 12 or 13?
13 and 14 both.
8 ওটা শো করছে তো 13 12
13 and 14.
না শো করছে তো ওটাই শো শেষে তো হ্যাঁ আমার তো কিছু বলা তুমি কিছু করে
My lord, 13 and 14 is both are analogous matter, my lord. It is one is the husband and another was the wife. It's
অরুণ কুমার সারাফ and সরোজ সারাফ.
yes, ma'am. So, my lord,
Give me a second.
কোনটা দেখছো অরুণ কুমার
so item number 13 is Arun Kumar Saraf, right?
14 টা কোথায় গো? আগে আরেকটা ফাইল দাও.
My lord, in this matter,
Who is for the state?
I appear for the state in 13 and my friend appears in 14. No, I'm for
You are for in 13, you are in 14. And you are for
the main
Hitco, my lord. The respondent number 2 and 3 are the proper blood answer. Hitco.
you are respondent number 2 and 3 in both the matters.
Yes, ma'am.
The premises numbers are different.
May I check what is the time?
Because your prayer to transfer the allotment of the premises number such and such to Srimati Saroj Saraf, who is the writ petitioner in the second writ petition.
I have given the what is the question of law? No fact. My lord never conceived of. After granting of probate, can anybody ask for heirship certificate? A will. I am really laughing after looking to this. Probate application was there, probate filed, court granted probate. Produced before the authority. Now, this is the probate, last desire of the testator, and his name, the allotment was there. So kindly accept this probate and grant in favor of the beneficiary.
Mutation.
Mutation. And the allotment also. Kindly come to the order, page 82, in 9005, 9055.
In 9055, yes.
He is the beneficiary. Kindly come to 82.
Page number 82, sir.
82. Can I read this? Keeping in mind, a probate was granted, that probate has been filed before the authorities.
Colon বাবু
ঠান্ডা হয়ে গেছে।
Arun Kumar Sara, that is the representative the executor to the will. Yes, Mr. Basu.
Can you read the second paragraph? Keeping in mind, my lord, that probate has been granted
In
and
the
probate has
to
been filed
inform that
before
on the date of will of Kedarnath Atto was neither in
legal year certificate.
on the date of the will of Kedarnath Sara. The above plot was neither in possession of Kedarnath Sara not
Well, facts of the case I will come later.
No, Mr. Basu, the first paragraph is equally vital, sir.
Can you read? May I read?
Yes, sir.
The above, I am directed to inform you that on the date of will.
The date of will means the date of execution of the will.
Maybe.
Yes.
I think so. Kedarnath Saraf, the above plot of land was neither in possession of Kedarnath Saraf, nor deed of sale has been executed in the name of Kedarnath Saraf. I will come to that later. Can you come to the bottom?
Yes.
This is the ground of challenge before my lord. When there is an probated will, can the legal head certificate or successor certificate can be asked?
Will covers this property?
Yes,
That I intend to
this is
know.
the only property.
Have you annexed the affidavit of stray asset?
Everything. Probate grant is here. But kindly come to 39. Plotting, my lord, as page 44.
Page number,
44 is the my lord, which my lord's query. State order of land was allotted to me by HITCO.
The land owned by me consists of freehold number such and such, measuring aparato, as allotted to me by HITCO, and I have absolute right and interest over the same.
That part I will come later. Whether I have a right, full right or title interest, that will come later.
Huh.
So can you see the next paragraph? Who is bequeathing?
Son's wife, Srimati Saroj
Yes.
Gupta. No, that is the recital of the will.
Yes. That has been probated.
Absolutely.
So if that is,
but if it be the case, Mr. Basu, if it be the case that on the day of execution of the will, the testator was not the owner of the property.
my lord is well aware, my lord, probate court will not go to the title of the property.
Naturally. Of course
That's
not.
why I keep this segregated.
Absolutely.
Kindly consider the impugned order, whether in respect of a property where the will has been probated, a succession certificate can be asked for. There is no other ground given. Even if, my lord, the first part is which my lord is referring to, if I am not the owner, then irrespective of the fact that whether there is success certificate or not, no matter.
Intestate succession will follow.
I am not the owner. If first paragraph, which my lord is pinpointing that he was not the owner.
If he is not the owner of the property, and whether there is a probate or whether there is succession, no matter.
No matter.
So that's why my lord has to consider in this writ whether when the probate has been granted by a competent court of law, whether for that purpose, that property, a successor certificate can be asked for.
So what do you want? You want consideration of your application on the basis of the probated will.
Yes. Now, my lord, now kindly come to the merits of the case. Or kindly come to page 29. This is the allotment. With reference, has Malkali got it?
Yes, sir. Got it.
With reference to our application being number such and such, addressed to Kedarnath. The allotment of the plot in Newtown, Calcutta, I am directed to state that a plot may be demised to Kedarnath Sarab allotee in consideration of the total price of rupees 7,17,000 for the plot for which particular are appended below, subject to final demarcation of the plot at site. Well, this is the plot number. Now kindly see the payment.
This is a letter of offer.
Letter of offer. What is the letter of offer? Accepted by us. 1, 2, 3, 4.
Payments.
Payments. These 4 payments has been made. Has Malkali got it?
First installment has already paid.
First up to 4th.
Your contents.
That's the admitted fact. The documents are annexed here.
Achha.
5th, kindly come to 10%, 71,000 at time of possession of the plot.
Very good.
According to them, possession has not been handed over to me.
Deed was executed.
No, unless this is done, deed cannot be executed.
In the meantime, the testator passed away.
Passed away. We wrote to them, the testator passed away, and there is a will probated by the court. Kindly now grant me this. Now, why I can be charged? Kindly come to the bottom. Item 2. Price escalation. This they may ask for. Price escalation up to rupees 1,43,000. That is 20% of the original price shall be payable along with the 5th and final installments. That is before giving possession of the plot. So this is the condition for which the allotment were granted. Possession admittedly not taken. I cannot take possession. Possession has to be given. Unless the possession is given, I am not entitled to liable to pay this.
So Basu, possession is one thing and title is another thing.
Title will come followed by possession. Here, unless I pay this amount, enter consideration is not passing. If the enter consideration is passing, no question of deed to be executed.
Very good, sir.
So today,
no, Mr. Basu, even if the consideration is not passed, even if and even then, if deed of conveyance is executed, title passes.
If deed executed, title passes.
Title passes.
Never execute any deed unless the entire consideration is paid.
So at the time of the execution of the deed. will, the testator was not the owner of the property, was not in possession of the property.
Allotee. Possession.
He was merely allotee. But he in the recital of the will, he has disclosed that he has become the owner of the property.
That is, I don't know why he has said that, because that not judgment for also consider, because even if he says in the recital of the will that I am the owner of the Victoria, I cannot be title cannot be recited.
Absolutely not.
Only here, my lord, we wrote to them, this is the situation, you kindly allot this plot in favor of the executor, the beneficiary of the will. This is the sum and substance. To that, their reply is that you give the succession certificate. They have not cancelled, nothing has been done till it is surviving according to my humble submission before my lord. This allotment is still surviving.
No, Mr. Basu, then what is the wrong in the letter? That I intend to know.
How can I give the, my lord, the succession certificate?
No, sir, they have not. Succession certificate applies in case of the movable properties.
What there
is a legal heir certificate.
What from we get it? The property has been bequeathed in terms of a will. If at all the title is to be looked into.
No, HITCO wants, basically, HITCO wants a legal heirship certificate, maybe from the council or whatever maybe, and other person will give a no objection that in the proper such and such person died, and if it is allotted to such and such person, we don't have any objection. Matter is so simple. I have made unless it's complicated, sir.
According to me, it is not simple. If the will is probated, desire of the testator is, my lord, reflected in the will, and that has been probated. So is
Sir
intention.
Basu, I understand your contention that a probate court will not go into the title. And rightly or wrongly, the probate court has granted the probate, being satisfied with regard to the execution of the deal with the testator. But this is not the probate court.
No.
HITCO is the allotting authority.
Yes.
Allotting, and he is going to he was ready to allot the property to your predecessor interest, that is the testator. Now the testator, he found that the testator was not the owner of the property, so naturally he has prayed for. So what is the wrong? I understand.
I don't make myself clear. May I repeat?
Repeat, sir, repeat. Absolutely.
I am an allottee. His writing is wrong. In the will, in the body of the will, it said, should be written there, I am an allottee. Whatever right I have, that because to Saroj, my wife.
Sir, that read court cannot interpret, sir. Read court cannot.
I request you also to ignore that part.
Yes.
Because the read court or the probate court cannot decide the title. Up till now, my lord, the Arun Kumar Saraf, my lord, the Kedarnath is the allottee. No doubt.
Absolutely, sir.
Whatever right he has as an allottee, he bequeathed that in favor of her, his wife.
That you say, but will does not say.
Yes, will says so.
No, sir. Read.
Well, kindly come to that.
Yes. Page 44 is absolutely clear.
Yes. Kindly ignore that part, that owner. Owner owner should be replaced as the allottee. Then kindly come to the bottom. I hereby, in favor of my son's wife, Srimati Saroj.
No, it cannot be done, sir. Very good. Any other points, sir?
So, whatever, my lord, she has the property.
No. Later is absolutely justified. Take down.
Then, my lord, this.
That is your headache, sir. What I will do. Ashwin.
Cancelled already. These letters have been issued.
I will cancel.
No, it has already stood cancelled. As per the letter of allotment, kindly seize the letter of allotment once. I shall trouble your lordship with only 2 clauses.
I will not go into that. Take down. And a copy number.
May I cite one judgment, my lordship?
Yes.
.387, your lordship kindly come to paragraph 12. Kindly come to
Paragraph 12 is at page number 396.
Before that, my lord, kindly come to 39.
Paragraph number, sir?
Paragraph number, my lord, kindly 11, last part.
Yes, sir.
Here question was that there is, so far as the Salt Lake properties are concerned, it are not transferable. The question comes up whether by virtue of an will, whether it is a transfer inter vivos as a present time or it is a future transfer, which offending the clause. If once, my lord, the will is granted and probate has been made, so it takes place after the death of the testator, and so it is not offending. So after the probate is granted, the desire of the testator is reflected in the will, and that has been given a stamp by a court of law. what he is saying in this case, he is saying that whatever property I have, forget my lord, for the time being that it is owner, allotee, is to be vested to my son's wife. So son's wife is now the beneficiary. Now allotment was in the name of Kedar. So probate has been filed before the authority that this is the probate. All the property allotment, if allotment cancelled, what he is saying, that is separate aspect. It is not here, neither there. Whatever property or the right you have, that has been vested to Saroj. So if the probate is granted, then were from the further, my lord, heirship certificate or, my lord, no objection from the others. If there is any, my lord, contested hearing, contested probate application, the objectors, caveators may have been there. So they have not participated, no objection filed. So probate is sacrosanct, bequeathing all the rights of the testator in favor of the son's daughter, as son's wife. If that is reflected in the probate proceeding, and which is the court of law had stamped it as a grant, then wherefrom, my lord, the Saroj will get, my lord, other no objection certificate. That is inbuilt in the probate. There is no caveat. There was no caveat, so it is not contentious. It is simply granted. So it can be presumed that all the so-called objectors who are the heirs consented to that. That is my submission. Here that has been, this is not a present time transfer, it is a transfer future.
Take down.
May I have my
Yes. এটা একটু স্টেপল করে দিন না ভাই।
May I have my lord's
No, I have stapler.
May I have my lord's kindly my lord, my junior is.
এটা কত নম্বর হচ্ছে, 13 আর 14 না? Yes. Since Item number 4, password matter.
I am for the petition.
এটা কে যেন এসেছিল? মিস্টার আদক এসেছিলেন তো?
Father was here in the morning. So Mr. Supratim Dhor was preparing his bed for some time.
Making not today only.
Lordship will kindly take it up on the next second of Lordship because
Second, I take up the
for a long
hearing
time,
matter. Not today. Only not today. Take the.
Kindly fix it on Friday, Lordship.
I'm not. Huh?
Fix it on Friday, Lordship.
Friday, I take up the adjourned motion matter.
Lordship, any day as per your convenience, Lordship.
Very.
Lord, I am appearing on behalf of the witness in this matter. Before I make
এই বোর্ডটা ঠিক করুন ভাই, বোর্ডটা ঠিক করুন।
প্রাইভেট সবাই আছে।
সবাই আছে, ঠিক আছে।
এসিগুলো একটু কমানো যায় না? ভীষণ ঠান্ডা লাগছে তো, হ্যাঁ? ওইটাই চলছে, সেন্ট্রাল এসিটা চলছে, খুব ঠান্ডা লাগছে।
Lord, I am appearing on behalf of the writ petition, Lord. The subject matter of dispute is that my brothers who are the private respondents before Lordship.
Who is for this? Oh, Mr. Dey is here.
Mr. Dey is always there. He's a government
You are for the private respondent.
may be permitted to file this supplementary affidavit. Your Lordship may kindly, Lord, I have served the copy of the
Sir,
supplementary.
why will all cases file the supplementary affidavit?
Actually, it was the desire of the court, not my desire. Your Lordship will kindly see.
I will serve advance copy to them.
I have served of both of them.
Give me a second then.
Lord, order
Give me a second, sir.
Fine.
Yes, sir.
Lordship has seen the order dated 9th of January 2025.
Page number?
The subject matter by which I was directed to file the supplementary affidavit. As to why, what circumstances came before or arose before the court that I was directed to file the supplementary.
Give me a second, Mr. Rai. Yes, sir.
Lord, a writ petition has been moved, Lord, challenging the action of the forest officer. Forest officer stands in my way that I should not change the nature and character of my land. That was not there. It is a plot of land on which, Lord, an orchard is there. Orchard is not new. It has been all along a orchard. My friends, my friend who is appearing on behalf of the private respondents, Lord, they are my own brothers. And Lord, the brothers, it is very unfortunate that.
So, what is the nature of the impugned order?
Lord, the nature of the impugned order, Lord, your Lordship kindly turn to the copy of the writ petition, which is the subject matter of challenge. P5, page 56. For a moment, your Lordship kindly go.
Page number 56.
Page number 56, P5 of the writ petition.
Give me a second, sir.
Lordship. Not collusion with each other. Only not collusion with each other. You are for the state. You have to be very impartial.
So your prayer for felling down the tree has been rejected.
That has been rejected.
And according to you, as per the degree of partition, it belongs to you.
My lord, there is no doubt about it. Lord, I'm just a minute.
Before my
Just a
land
minute.
No, sir, no.
Just
Wait,
a minute,
wait.
just a minute. It is very unfortunate. My own brothers, 4 brothers are one side. They are very much envious of me.
Be there as
Yes,
it
I have.
You
have,
place your case.
Yes, I have been using this plot of land as an orchard for a long time. But when I moved the
As an exclusive owner.
As an exclusive owner, there is no problem with regard to my right, title, and interest. When I moved the writ petition before the London Court, my lord, the London Court wanted from me that very well, Mr. I, you produce the purchase and the that the land is being used as orchard.
You are the subsequent purchaser.
No. I am the owner, my lord. I am the the son of Mr. Madhusudan Mandal. I am one of the co-sharers of the property. There is no dispute with regard to my property. And they have never disputed. There is no dispute with regard to the
Bodhan is the son of late Madan Mohan.
Late Madan Mohan. We all. Lord, I have all along been cultivating, using as land as the orchard. There is no problem. When the Honorable Court wanted from me that you come with some better particulars that you have been using the land as the orchard, but that is the reason the liberty was given me to file the supplementary affidavit. Lord, and the supplementary affidavit, Lord, in my supplementary affidavit, Lord, I have annexed all the papers. So, Lord, see for a moment, kindly see the supplementary affidavit. There is no dispute that the land is not being used as an orchard. I have annexed several documents showing.
No, it is not no question of orchard. Whether it is a joint property or is a individual property. How do you prove that?
Lord, there is a deed, also copy of the deed. Lord, my father partitioned the property amongst us by executing, Lord, his deed of settlement. And from the deed of settlement, Lord, all the brothers got their own shares. They got their names recorded, purchase have been issued separately. Then everything has been separated. Then where is the problem of my friends? And how can the forest officer can
Now
come
tell me in which plot your orchard is situated?
That is there. I have in my supplementary affidavit, I have stated very clearly, Lord. I have annexed all the papers. Lord, so we kindly see from Lord from page 11 onward, sketch map is also there. Lord, that plot number is also there. Page 12, Lord, so kindly see Bodhan Mandal, Rayat. Then Lord, page 13, that is there. Page 14.
Sir,
page 15.
try to understand my question.
My lord.
If the according to you, orchard belongs to you.
My lord.
According to you, orchard is situated on a plot of land.
My land.
According to you,
my lord,
orchard belongs to your own property.
My.
It is an exclusive property.
It is exclusive property.
Now tell me, what is the basis of your title?
My lord, basis of title is, my lord, that I have inherited the property from my father. I have inherited the property from my father as a co-sharer. Like
Inherited means by way of intestate succession or tested succession?
No, not tested, intestate.
Very
Intestate, I have annexed the copy of the deed also, my lord. Lord, there is no dispute with regard to my right title.
Inheritance?
Yes, in any way. There is no dispute with regard to the right
title. No, sir.
Yes, your lordship will see last 2 paragraphs of the order.
No, that I've seen.
No, that is what I wanted to see.
There is any partition. That is the Ismail property. How a person.
That I intend to know.
That I wanted to know. Bodhan as a plaintiff filed a suit for partition in respect of plot number 2322. That was non-prosecution by Bodhan. That fact has been suppressed in this writ petition. Can you see the plaint and the order?
The order is perfectly right, my lord. The last 2 paragraphs, my lord, he can't.
You are Mr. Rai, no? Mr. Rai, matter is very as simple as I am telling. You prayed for felling of tree,
my lord,
which is situated on an orchard.
My lord.
According to you, that orchard is situated over a plot of land
on my plot
of which you are the absolute owner.
Yes.
How do you prove that? That I intend.
Yes. Your lordship, kindly see. Lordship kindly see. Page 37 of my writ petition, Lordship kindly see.
Original writ petition.
Original writ petition. I have annexed a copy of that also.
That is the deed.
Page 23, your Lordship kindly see, and page 23. Page 23 of my writ petition.
Sometimes you are showing 23.
P1, page 23 of my writ petition.
What is that?
Lord, I have obtained the land area such and such, acres of motorcycle such and such, under PS such and such, Probate by deed number 216 for the year 1983, by virtue of family settlement, it from my father, Madhusudan Mandal. Now,
Wait. I have obtained the land area, so 1.04 acre in plot number 2322. Orchard is situated at plot number 2322.
And orchard is there in that plot number also given.
Where I will get that?
Copy of the deed also.
Plot number 2322. Yes. Now show me your deed. We have not given the translated type copy.
Lord, I may give your Lordship, if so, Lord, if your Lordship desires, I'll give the translated copy.
Where is the schedule? Where is the schedule?
Lord, the schedule was also there.
Tell me the page.
I'm taking. No, page 2.
It is a demarcated one.
The demarcated one, Lord. This is written in hand, Lord, in Bengali, in handwriting, Lord. I am also not able to read properly. Supplementary affidavit.
Well, kindly have a look the plaint of the suit in the plain. This subject.
Definitely I look. Let me check whether what is the schedule.
Lordship, kindly.
Topocil.
For a moment, Lordship, kindly take up my supplementary affidavit for page 19. Supplementary.
Sometimes you are showing this, sometimes you are showing that.
Page 19, Lordship, kindly see. Page 19 of my supplementary affidavit.
It's an application.
No, application is there. I have given the plot number, spaces, everything is there. Lordship, kindly see.
Oh, you just show that this plot number exclusively or the orchard exclusively belongs to you. Where I will get that? কি বলছি আর কি বলছেন কিরকম?
Lord, 2322 is the plot number, Lord. That is your Lordship will kindly find it page 19.
তপশিল দফায়
বাংলাতে এত মার্ক করো।
কিছুই নেই, বোঝা যাচ্ছে না।
এত বাংলা হাতের লেখা আমি পড়তে পারছি না। দেখা আছে হাতে, আপনি একটু দেখান তো বাংলা হাতে।
Suit for declaration of title and permanent injunction.
আপনি এখানে দেখেন হাতে লেখাতে কোথায় আছে প্লট নাম্বার, বাংলাতে হাতে লেখা আমি করতে পারছি না তো। একটু দেখুন, আস্তে আস্তে করে দেখুন আপনি বাংলা।
আমরা মে আই রিড
order
মাইলর
দিচ্ছে, আমরা করছি এটা করবো, তখন কি
না না
বলবো?
ঠিক আছে 23 শতক 22 শতকের 16 আনার 5 একর 32 শতক মধ্যে অত্র খতিয়ানের 2 আনা 6 গন্ডা 2 গড়া দুপ্রান্তি অংশে
At
1
that
একর
one, whether
1
a
একর
demarcated portion has been given or
They
undemarcated
they
portion.
filed
that
the
is
probate case and
My
that
lord,
they
one
lost
thing, my lord.
before all the problems.
My lord, kindly, my lord, one
Probate
thing.
case ও file করেছি।
My lord,
কত 32-33 what matter 28
Mr. On Manager Lordship, in this matter, if your Lordship remembers this matter, on the last occasion, we have filed our, except the respondents have filed their.
give me a second. Yes, where is Mr. Banerjee?
He is on his left, Lordship. May I just indicate the facts in brief to your Lordship?
Who is your other side?
Mr. On the item number 32, Mr. Supratim Dhar.
Mr. Ganguly and Mr. Supratim Dhar.
Mr. Supratim Dhar and senior advocate was appearing in item number 32, and
Ah.
item number 33, Mr. Tarak Karan was appearing.
Adjust the microphone, sir.
Lordship.
So where are they?
Lordship, your Lordship was pleased to fix the matter today, Lordship, at 2 p.m. On the last occasion, we
Probably
had
they are still under notion that I am in Jalpaiguri. Probably so. Keeping his password for some time.
Yes, your Lordship.
If possible, please inform your other sides.
Lordship, I shall.
What's your good name, sir?
Himan Banerjee, Lordship.
Mr. Adak, there is a Bengali proverb.
No, my lord,
"Rauদ্র ছায়ার খেলা."
my lord, 2-3
So
weeks.
you are doing from the morning this way.
My lord, I also, my lord, call Mr. Dhar, my lord. My lord, I also request him, my lord. Problem is, my lord, everything is, my lord, Mr. Siddiqui resigned, my lord. I transfer to the, my lord, Mr. Dhar, my lord. This is the problem is happened, my lord. One brief, my lord, entire, my lord, file is, my lord, lying, my lord.
Mr. Adak, I know you for a pretty long time. You also do very well.
My lord, my lord.
Get yourself ready.
My lord,
I cannot.
Because, my lord,
For anybody, the court.
No, my lord. No,
I
this
fixed
is-
it on day after tomorrow.
My lord, this
At
is
the top
habit.
of the
My
list,
lord,
if you
my
don't appear,
my lord,
don't appear.
my lord.
I will send the order to the legal department. Call the next item. Mr. Banerjee, I am keeping it password. If possible, please inform your other side.
I shall briefly.
Next.
My lord, in item 34, my lord, and this is a change brief, my lord. Mr. Kollol Basu has been briefed in this matter only a day or two ago. We are seeking a brief adjournment, my lord, subject to your lordship's kind approval.
Fix it under the heading specially fixed matter at 2
My
p.m.
lord, I'm aware Mr. Manna was arguing this matter before, but then it is a change brief, my lord.
So what do you want?
A week's, if it could be kept in the first week of September, my lord, as a fixed matter, my lord.
On behalf of the petitioner, You start. Let us start. 32 is 33.
Both of us here. I have also raised. So let me. I started this matter then not because. Kindly allow me to.
No,
place this
Mr.
matter
Banerjee, what happens? No, if you keep, if I keep part-out matters pending,
Yes.
I'm telling you, after
Should they argue the maintainability, then I can address that also. The maintainability point, if it is maintainability point, then
Because
possibly
of the fact,
you should
my
point out so that I can answer.
after the judgment of the Honorable Justice, kindly see the page 67, my lord,
Page 67 of what?
of my opposition, my lord. And my lord, probably that was also annexed with the repetition also.
In item number 32, sir.
কোনটা চাই সব গেটটা জাস্টিস লালার জাজমেন্ট তো
কত
ওটা হচ্ছে
annex করা আছে।
পেজ 48 of the writ petition.
No, he is when he is saying affidavit in opposition.
Affidavit of my lord, the BSNL, my lord.
Yes, Mr. Ghosh.
Yeah, please, my lord.
Page number?
Page 67, my lord. My lord, the predecessor of the present writ petitioner filed the writ petition. My lord, the writ petition number, my lord, the 18458 W of 1998, my lord. Prashanto Kumar Chattopadhyay versus State of West Bengal and others. My lord, that was disposed of by the Justice Amitabh Lala, my lord. Two courses are open for the purpose of finalizing the writ petition. Firstly, a provisional assessment of compensation which has been made under section 72A 8BJ of the West Bengal Land Requisition and Acquisition Act 1948 on the basis of the notification dated 28 January 1994. Such compensation respective
Mr. Banerjee, please take your seat.
But subsequently it was found that no notification was issued under such section on that very day. The actual notice was issued on 5th January 1995 and it was notified on 13th February 1995. Therefore, two courses are open which the collector has to decide whether the amount of compensation will be made on the basis of appropriate notification issued on 13th February 1995 or the notification issued on that very day. A fresh notice is to be issued for the purpose of determination of the compensation. Therefore, the decision is to be taken by the collector on the issue on the basis of the submission made by the petitioner and upon taking into all
Pros and cons
in this respect of the matter. Such order will be passed by the collector within a period of 2 months from the date of communication of this order. Secondly, a letter to the collector Hooghly dated 18 September 1988 was issued whereunder the portion of the plot number 892 with area 0.35 acre, that is the appertaining to the acquired land, has been left aside and the collector wanted to the concerned district engineer to submit a fresh proposal under the Act 1 for such portion. According to the petitioner, such portion will have no use of the said step has not been taken. There was also a proposal which will be reflected from the letter dated 18 September 1988 that the land will be given to the chairman to the local municipality for the purpose of taking over any scheduled purpose. The petitioner is facing a lot of difficulties in respect of the same, but cannot force the authority to proceed out of his own violation. According to me, the analogy under section 49 of the Land Acquisition Act 1894 is to come to a rescue in respect of the matter, although the said provision is made for the purpose of appertaining to the to building or manufacturing or other buildings, but the question of dispute as regards the same can be decided by the court to rescue the petitioner on the basis of available records and on a topography of the land in question. Therefore, such dispute can be resolved by directing the collector to refer the matter to the concerned court for the purpose of disposal of the same. Till such decision is made, no final publication of award will be made. The writ petition is thus disposed of. There will be no order as to cost. So, my lord, after this order of 1998, my lord, till date, that collector has not yet been, my lord, referred the matter to the concerned civil court, my lord. And my lord, they ought to have take steps. Petitioner ought to have take steps in compliance of that order, my lord. But instead of that, my lord, they have filed 2 writ petition. Actually, 3 writ petition. One is, my lord, that their father, and thereafter this.
Give me a second. So therefore, such dispute can be referred by directing the collector to refer the matter to the concerned court.
That direction is already there, my
Your Lordship.
And my lord, since
Under Act 1.
Yes,
For reference. For reference.
Reference, my lord, that
Hey,
provision
Act
of the
1
Act 1 was, my lord,
Section
adopted.
18.
Huh.
Reference section 18.
Then what is this?
Award has to be declared first, then reference. Here, award was not declared.
Then what the civil court will do?
Because, my lord,
Hey, Barkun,
My lord, that order was also not challenged.
what happened, my lord, initially,
Land Acquisition Act.
initially the acquisition was for 1.22 acres, the entire land in Act 1. Act 2, it was for 0.87 acres. We challenged that, saying that you are not taking the entire land.
Please enlighten me. Therefore, such dispute can be resolved by directing the collector to refer the matter to the concerned court for the purpose of disposal of the same. So, what are the disputes? With regard to the quantum of compensation, and another is with regard to the acquisition of the land.
No, they were not acquiring the entire land. That was the dispute.
Yes, that was seen.
Not the quantum, because award was not declared. Quantum shall arise only after the award is declared. Then only we can say quantum is insufficient under section 18.
No, here, Mr. Banerjee, it has been stated. Therefore, 2 courses are open to which the collector has to decide. Page number 68, sir.
Lordship.
Whether the
Lordship. Advocate Mr. Supratim Dhar is appearing for the state lordship item number 30.
I am not granting. I am not
Please engage lordship.
No, this way cannot be done.
Kindly.
I am hearing.
Not today, lordship.
No, sorry. It cannot be. Yes. You take note. No, 2 courses are open, which the collector has to whether the amount of compensation will be made on the basis of the appropriate notification. Notification under which act? Act 1.
At that point of time, it was Act 2 converted to Act 1. If this is a submission of
Well, the
merits,
analogy of
have to
Act
place
1
the
was
facts.
adopted.
I thought it's a point of law.
Why made is maintainable? Why you are
Yes, my lord, because my lord, the earlier writ petition, that order was still there, and my lord, that was not, neither that was challenged by the state, not by the challenge by the writ petitioner or their petitioner. So my lord,
Sir, I understand.
that is
But
my
by
lord,
the
still
order,
binding upon all us.
order of the coordinate bench, the matter is to be referred to the concerned court under which provision?
My lord, that Honorable Justice Lala, my lord, adopted the provision of the Act 1. My lord, kindly see the last 4 lines. 1, 2, 3, 4, 5. Last 6 lines from my lord, the second page of the order, my lord. My lord, may I place that?
No, sir.
According to me.
Wait, Mr. Ghosh. No, please answer to my question. Therefore, such dispute can be resolved by directing the collector to refer the matter to the concerned court. Sir, under which provision? That I intend to.
My lord, under the Act 1 provision.
I mean, provision section 49 kindly comes to 49. His lordship has also recorded for 49. Kindly come to the bottom of the page. According to me, analogy of section 49 of Land Acquisition Act 1894 is to come to rescue. 49 is if a part is acquired and the rest is not acquired, then 49.
Oh, I see.
Maybe invoke.
Let me see.
Directed.
Very good. I understand. Mr. Banerjee, please place your case.
Now
Please enlighten me. What is the facts? What are the
I'll
facts?
just place the facts. So initially, Act 1 in 87, admittedly lapsed.
Mr. Ghosh, please take your seat.
Yes.
Act 2, initiated on 25th of August 1993, page 35. Under Section 3. Act 2, Section 3, on 25/8/1993.
Page number?
Page number 35 of the writ petition. This was regarding 0.87 acre.
Page number 35.
35.
What is this, sir?
This is not the Section 3 notification. Form of order requisitioning land under subsection 1 of Section 3 of the West Bengal Land Requisition Acquisition Act. Notification under Section 3.
Act 2 of 1948.
Act 2 of 1948.
Yes.
This was followed by, my lord, an ad hoc payment under Section 8B. Under Section 8B, my lord, when you take possession of the land, you should make ad hoc payment. That is Section 8B of the
Page number, sir?
No, that is not annexed here, my lord. The respondents have annexed. Opposition. In the opposition, I will give the page number of the opposition.
Very good.
Then, my lord.
Ad hoc payment made.
Ad hoc payment made. This is one of the arguments of the state, my lord, that ad hoc payment made, so you cannot challenge it. Then, 5th of
Ad
January.
hoc payment made under Section
8 capital B of Act 2.
Then what happened?
Then, my lord, on 5th of January 1995, notification under Section 4(1)(a) of Act 2 was issued, following Section 3 notification.
Page number?
Page number 37. Annexure P8.
One small a.
Right.
Notification. Page number 37.
Page number 37.
This is a memo.
So, this is a notice. 37. And your lordship is looking at WPA 3669.
No,
The other
it is 23317.
2331.
Which one will take up first?
I was referring from 3669, which is the previous one. I'll give the number from the second block. Second repetition, the page is 34. No, Joshua, second.
I'm taking up the item number 32, sir.
32.
Tell me which will be convenient. I will take up that matter.
No, real lordship is looking at not 23317.
Yes,
I'll refer from, or your lordship takes not 3669. That is better because my noting is on the first.
That was asking.
Otherwise the pages will not match.
এই ফাইলটা দিতে বলছে তুমি লোক এখন আবার এটা দিন page number 35 is same.
35 is Milord. Here Milord 37.
Yes, on the last day you argued from here.
35, yes Milord. 35 I have shown your lordship. It is a section 3.
Page number 35 is the section 3 notification. Yes.
Followed by page number 37, which is the section 4 notification.
Sir, let me note, otherwise I will forget. WPA 366 9 of 2025. Page number 37. Page number 37 is the notice under section 4(1)(a).
37 is the notice under 4(1)(a). Then
vesting complete.
Vesting took place. Then award was not declared. Act came to an end on 31st of March 1997. Act was no more in force.
Award not declared.
Not declared. Then, my lord, the petitioner
and the act took lifetime of act 2 of come to an end.
31st March 1997.
31st March
1997.
As per the Amendment Act.
As per the amendment, life came to an end. Then, my lord, the petitioner, unaware of this legal position that the act has expired, he pursued, my lord, for relief that the entire land should be acquired in line with section 49. But strictly speaking, my lord, section 49 will not appear to a land. That is why the court said analogy of section 49, because 49, my lord, applies to building, manufactory, etc. Anyway, the court has adopted the analogy and directed reference. So we filed a writ petition. Writ petition is of, my lord, the year 1998. When the act had expired, no award. Lifetime of the act expired, writ petition was filed.
The previous one.
Previous one, which my learned friend showed.
That is WPA.
WPA 18458 W of 1998.
WPA
18458.
1418.
18458.
I'm sorry, 18458
of 1990. W of 1990. Now, this writ petition was disposed of on 19th of February 2003.
19th February 2003. By Justice Lala.
Justice Lala. Here, my lord, direction was given that you refer the matter to the civil court. Till the decision, you cannot pass an award. Now, their point is that since this direction is there, this will govern. You cannot come up for the second time. Now, I'll explain why I can come. For two reasons. Lord, the state.
They are the requiring body.
They are the requiring body. When this matter was taken up, my lord, the state was not present. So, nobody pointed out that
Act 2 has come to an end.
Act 2 has come to an end. The proceeding was converted into Act 1 under 9(3)(b). Proceeding was converted under section 9(3)(b).
Just a minute. So when the order dated 19/2/2023 was passed, a lifetime of Act 2 of 1948 came to an end.
Came to an end. There was on Milord 15th of February 2001, a notice under section 9(3)(b) was issued. 15th February 2001.
15th February 2001 notice issued under
section 9(3)(b). This your lordship will get at page 56.
3B issued.
9(3)(b) is opposition.
Page number
56. 9(3)(b) to that. Now, your lordship will find this is a communication.
Page number 56.
56.
Page number 56 to the match করছে না
56
WPA page number 56 of WPA 3669.
469. This is not a notice. This is a communication from where we shall get all the dates.
Say that.
Interdepartmental correspondence.
Kindly place, sir.
My lord. The undersigned is directed. This is regarding Lord LA case number 1:4 9394. The construction of Tarokeshwar Bishnupur telephone exchange. Same acquisition case number. Undersigned is directed to refer to his memo number 1882 LA dated 13/9/2007 on the subject mentioned above, and to say that as per his report, notice under section 9(3)(b) of Amendment Act 1 of 1997 was issued on 15/2/2001. As such, the instant delay proceedings under section 9(3)(b) stand lapsed with effect from 14/2/2003, irrespective of the restraining order dated 19/2/2003 of the Honorable High Court. High Court passed on 19/2. It had already lapsed not on 14/2.
High Court passed an order
on 19/2/2003.
19/2, yes.
It says that it had already lapsed, irrespective of the order of the Honorable High Court. Therefore, he is advised to start the LA proceeding again under section 9(3)(b) in respect of the other land excepting the land of the petitioner before declaration of award after obtaining leave of the Honorable High Court. So the proposal was that this had already lapsed. You initiate a fresh proceeding under 9(3)(b), and the land of the petitioner, since there is an injunction by the High Court, you cannot touch. This was the order.
No, that can be done after obtaining leave from the High Court.
But in my humble submission, no, it cannot be done, because now kindly 9(3)(b), if it lapses, there is no provision for initiating 9(3)(b) again. Everything goes. Your lordship will kindly take up amendment. I'll just place, my lord. Under section 9, my lord, your lordship will get, my lord, West Bengal state amendments. In Act 1, after section 9, there is West Bengal state amendment. Section 9(3)(a) is inserted, 9(3)(b) is inserted. After that, I am reading the proviso. That the date of publication of notice under subsection 1(a) of section 4 of the Act shall be the date of reference for the purpose of determining the value of such land under this Act. Provided further that in every such case, the collector shall make an award under section 11 in respect of such land only for the purpose of payment of dues compensation to the person interested upon collector taking possession. Already vested. No, there's one more amendment, my lord. Just a second. Yes, ma'am. Kindly come to 11 capital A. That is under 11A. Kindly come to 11 capital A.
The collector shall also serve notice on the ability to have to entitled to have to already taken position under section and notice also been published under section 1(a). The provisions of the section 4, 5, 6 have to
that part is compliant.
The notification under section 4(1)(a) shall be the date of our reference of to. Therefore, in every case, the collector shall make an award under section 11 in respect of such only for the purpose of payment of Athur. Then upon the collector taking possession thereof, the vested also.
So 9(3)(b) is complied by them. 9(3)(b) was complied on 15th of February 2001. Then kindly comes to section 11 capital A.
11A.
11 capital A. 11A I am reading. The collector shall make an award under section 11 within a period of 2 years from the date of publication of the declaration 2 years from the publication of declaration, and if no award is made within that period, the entire proceedings of the acquisition of the land shall lapse. Provided that in a case where the said declaration has been published before the commencement of the Land Acquisition Amendment Act 1984, award shall be made within a period of 2 years from such commencement. Explanation: in computing the period of 2 years referred to in this section, period during which any action or proceeding to be taken in pursuance of time said declaration is stayed by an order of the court shall be excluded. Then West Bengal Amendment. This is relevant for our purpose. In its application to the state of West Bengal, after the proviso, the following proviso shall be added, namely, provided further that in respect of the acquisition of the land referred to in subsection 3A and subsection 3B of section 9, award shall be made within a period of 2 years from the date of issue of the public notice under section 9. This is relevant for our purpose, my lord.
What does it say? The provided further.
Further,
in respect of the acquisition of the land referred to in subsection 3A and award shall be made within a period of 2 years
from the
from
date
the
of
date of
issue
issuance of the public document.
public-
So publication of notice under section was done when?
15/2/2001, 9(3)B. I've shown your lordship page 56.
Yes, you have shown.
9
So 2 years have elapsed.
lapsed, my lord, on 14/2/2003. 14/2/2003.
Just a minute, sir.
And the lapse is also admitted.
So Mr. Mr. Banerjee, when notice under section 9(3)B was published on 15/2/2001, then as per amended provision of the section 11A, the award has got to be declared on or before 14/2/2001.
3. 1 to 3.
Oh, I'm sorry. 2 years.
2 years.
And if that was not award, if no award was declared, the proceeding lapsed.
Then 11A applies. This is not a proviso only. 11A says if it is not done within 2 years, then the entire proceeding for the acquisition of the land shall lapse. This is very important. We have to see 11A, the first part. Collector shall make an award within 2 years from the date of publication of.
So what is your case? It has lapsed.
It has lapsed. Admittedly lapsed. Now, my lord, this notification came to our knowledge much later. When the first petition was moved, my lord, no, the court was also unaware, petitioner was also unaware that there is a lapse. 2 years have passed. The notification under 9(3)B was not, we are not aware. Court directed that you apply the analogy of section 49 and refer to the civil court. In the meantime, it had already lapsed.
So it was not brought to the notice of the coordinate bench.
Not of the coordinate bench.
Very
Now, my lord, after that, two things happened. The state filed a recalling application of that order of the coordinate bench of 2003. And that was kept pending from 2003 to 2020, 22 years, no steps taken. Just my lord filed the application and kept it pending. Did not comply with the order also. Nothing done. 1/1/2014, Land Acquisition Act 2013 comes into force. Section 24 of the Act is very clear that if award is not made in respect of any proceeding, then the provisions of 2013 Act will apply.
Kulhan Babu,
Section
2013 একটা বার করুন ভাই। Oh, thank you.
Finally comes to note section 24. Notwithstanding anything contained in this act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, when no award under section 11 of the said Land Acquisition Act has been made, then all provisions of this act relating to the determination of compensation shall apply. Now, this is, my lord, irrespective of any injunction of court also. It does not say that if there is a stay, then it will not apply. Irrespective of stay, 24 subsection 1 will have application. This is a subsequent event.
So you are referring for 24 within bracket A.
24 1A.
I'm sorry, 24 1A.
1A. That they have not declared the award. So in any case, if calculation is made, if your lordship holds not that the proceeding had lapsed, then everything goes. They have to initiate a fresh proceeding or return. If your lordship holds that no, it has not lapsed, then also they have to calculate as per the provisions of the new act. Maybe the proceeding will continue, but the calculation as per new act. So 100% solatium can't be 30% solatium. 100% solatium and other benefits to be given. My submission is that it has to be from today's date. Because
no, you referred, Mr. You referred page number 56.
56.
Which says that to refer to the authors of such order and to notice under section 3 was issued on 15/2/2001.
So it had
so
lapsed.
within 2 years, no award has been passed.
That is their own admission. They cannot. And in affidavit
so proceeding lapsed.
Proceeding lapsed.
So 2013 will apply.
13 will apply. Now, my lord, further things happened. I filed this writ petition 3669. In this writ petition, my lord, my prayer was they were not continuing the declaration that the section 401A, etc. have lapsed. I challenge you, Lord, by saying that I got this notification.
Just a minute, sir. Let me reach.
Page 22 is the prayer.
Yes, sir.
My first prayer was, my lord,
a declaration be given that the notification under section 401A as have lapsed. That is your prayer.
This is not the second writ petition. I'm sorry. This is the second writ petition. I'll just indicate. Lordship need not open the other one. I'll just indicate. I filed a writ petition challenging, Lord, the land acquisition proceeding, asked for return of land. Matter was taken up. They sought time for taking instruction.
In item number 32.
Other matter, 32. They sought
item number 32. What is your prayer?
My prayer is, my lord, payment of compensation as per the 2013 Act. Payment of compensation as per 13 Act. And also for payment of rent compensation, because there, if it is held by your lordship that the requisition was bad.
Calculate the payment of compensation. Yes.
13 Act and rent
compensation under the Act of 2013.
13. This seat was moved. They sought for time to file report. After that, my lord.
Where? Yes.
Kindly come to page 57 of the second read, 3669, which your lordship is taking note of. 3669, page 57. My first read was moved.
Yeah. Why two read petitions?
Because during pendency of the first read petition, they initiated a proceeding in compliance of the 2003 order. They said, now we are complying with the order.
Oh, I see.
They did not refer to civil code, but they passed an award. They passed an award and declared a compensation that I am entitled to this amount.
And according to you, that cannot be done, but the proceeding lapsed.
Cannot be done. Even if you are saying you are complying the High Court's order, then you have to refer to the civil code. Without doing that, you cannot calculate also. So those subsequent action is bad. I have challenged the subsequent action in the second read.
Achha. That
is why two read petitions. Kindly see page 57. This is the first order. 1st December, they seek for time to use the report.
Just a minute, sir.
BSNL was not a party, they are added.
Page number 57.
57, 1st December 23. Then, my lord, page 58, the matter was again taken up in February 24. When Lord added respondent did not appear, state again sought for time. Then, my lord, next page 59, they initiate this proceeding in compliance of the 2003 order, page 59. 6 November 24. In compliance with the order dated 19/2/2003, Honorable Justice Amitabh Lala of the Honorable High Court in connection with WP number 18458, notice for hearing was issued on 19/4 and hearing was taken on 29/4/24 in presence of Devashish Chatterjee, who attended for himself. Also on behalf of Sudha Chatterjee, Subhashish Chatterjee, Mousumi Chatterjee, copy of the order passed by the additional district magistrate is now sent herewith for your information, taking necessary action. Now the order sheet is annexed. Lordship will kindly come to me, Lord. 19th June 2024. What they are doing. Firstly, my Lord.
So without referring to the civil code, they have passed an award.
Firstly, if you are saying we are complying the court's order, then comply it. They have not complied. Secondly, admittedly, it is lapsed. And thirdly, 2013 Act has come into force. Nothing considered. The matter was taken up, took time for instruction, then this thing started. Because they got the copy of the writ petition, they became anxious that nothing has been done by them. In the proceeding, my Lord.
Just a minute, sir. Mr. Banerjee, show me the relevant portion of the order.
Order, my Lord. Kindly come to the order sheet, dated 19th of June 24, my Lord.
Kindly, please.
I need to, my Lord, show the first paragraph because written submission was made by the writ petitioners. Our representative went saying that the issue of 87 decimal and 1.22 decimal is no more relevant. That submission was made because everything had lapsed. From the written submission of the legal heirs of the writ petitioner, it appears that the disputed issue, which the Honorable Justice Lala had directed to resolve before publication of the award, has already been resolved. And the representative present in the hearing has categorically mentioned that the disputed issue is no longer relevant at present, and also only issue important to them is award for the acquired land of 87 acres in the suit plot.
So, which is why they proceeded in such a fashion.
No, the submission was made on that day, so they could not have called for the hearing. They should have referred the matter. But anyway, the petitioner went and said that the issue is no more there. Issue is no more. Then, in view of the above development, as the disputed issue, issue has already been resolved as stated by the legal heirs, then it can be undisputedly accepted that the order of the Honorable Court has been complied with. And there is no bar now to declare the award, which was kept in abeyance.
According to there is bar because of the lapse of the proceeding under Act 2.
Act 2. 11A, proviso. So the entire proceeding is gone.
Achha.
There is a bar. And they have proceeded under Act 1 here also. I'll show that. So that is also a bar. 2013 Act has come.
Yes.
If you declare award today, it has to be as per 2013 Act.
Yes.
That is also so two violations. So then they went on, Millard. Some strange things. They have taken the date. Kindly see, Millard. Second page, last page, Millard, last two paragraphs. As the date of the award of this particular LA case for all landowners, except this particular writ petitioner, is 10/7/2009. The award in respect of this writ petitioner should also be declared on the same date, after deducting 80% land value already paid. I don't know how they can declare on a date 10/7/2009 when everything has lapsed. This is also very unclear. Why 10/7/2009? To him, for the sake of natural justice, petitioner is further allowed interest at the rate of 8% of the amount payable to him. Now, the calculation which was given, my lord, clearly, sir, page 65 is the calculation.
Yes, Mr. Banerjee.
Now, kindly comes to page 65, my lord. This is the, my lord, calculation of the award. Kindly comes to the details of the award at the bottom, page 65. Plot number 891. Page 65 at the bottom. Plot details of the award.
Yes.
Plot number 891, acquired area 87 acre, awardee share 10,000, land rate so and so per acre, land value of acquired land is 4,06,000,
Hmm.
and solatium is 1,21,000. So that is 30%.
Inadequate.
So they have calculated as per the old act. So even if it is assumed for sake of argument that there was no lapse, then also this calculation is bad because.
So what is your prayer in this petition?
In this petition, I have challenged all these orders.
All these orders.
All these orders. So I say, firstly, in view of the admitted lapse, page 56, they have to, today they have, if they want to use the land, they have to acquire afresh. Number one, that is my first prayer in view of the amendment of 11 capital A. And second prayer is that they have to pay the rent compensation, and these orders are all bad because they could not have passed these orders.
Very good. I understand.
So these are my points, Milord.
Mr. Ghosh.
If they rely on some judgment, I'll deal with that because there are some judgments on.
Apart from maintainability, what do you have got to say?
This one.
You are from BSNL, no?
My interest regarding the BSNL matter.
Huh.
And what will be the effect regarding the prayer B, that is the after lapse, that will be replied by the state matter. Malad, kindly see for a moment, as because the state is not there, but this is Malad. Kindly for a moment, Malad,
No, ultimately, order in the event is order is passed.
I am the requiring.
We have to pay.
I have, my lord, most unfortunate thing is this: we have already paid more than 66 lakhs.
That is different thing. Be that as.
My lord, for a moment, kindly see page 51.
51 of what? Item number 32 or 33?
Yes, ma'am. The 366925, the second writ petition.
Page number?
Page 51. That is also the order of Justice Lala, my lord. My lord, the order was passed on 19th of February 2023.
Hmm.
And my lord, then my lord, kindly compare the page 56.
Yes.
That is lapsed with effect from, my lord, 15th of February 2021.
15th of
February 2021.
No,
2001.
This was 2001.
2000.
It lapsed on 14/3.
Yes, my lord.
15/3 it will lapse.
My humble and respectful submission is this. My lord, thereafter, that order was passed after the alleged lapse, or what will be the next steps? Nobody has come before this honorable court. If there is any wrong or recalling, no application, nothing. Everybody is silent, even the petitioner also. That fact may be considered, my lord. And my lord, kindly take the first writ petition.
And call Mr. Dhar. I will not wait.
In the earlier writ petition also, my lord, the first writ petition, 1998 writ petition, BSNL was not the party. Even in those writ petition, my lord, BSNL was not party initially. They have been, my lord, according to the prayer.
So in WPA 23331, which page is relevant?
My lord, page 4, paragraph 7.
Petition is concerned, what is your submission?
My lord, kindly see, my lord, regarding the acquisition, they never challenged. My lord, kindly see page 4, paragraph 7.
Paragraph 7.
Yes, ma'am. The said Prashanto Kumar Chattopadhyay informed the authorities that he had no objection if such property was acquired for public purpose. Your lordship got it? However, the Prashanto Kumar Chattopadhyay was served with a notice under section 5A of the Act 1894, by which he was asked to produce document in support of ownership. So, my lord, that acquisition was never challenged. That is an admitted fact.
It's a question of law is only involved.
Yes, my lord.
It's a question of fact. That's all.
No, no, my lord. Kindly consider my opposition.
So, for raising no objection, what will serve?
Yes, my lord.
Raising no objection, how it is helpful for you?
Then, my lord, only question of
Mr. Banerjee
quantum
Mr.
of compensation.
Mr. Ghosh, try to understand. Mr. Banerjee has raised a pure question of law that on such and such date, a notice under section 9(3)(b) of the Amendment Act was published. Law says award has to be declared within 2 years. If not, it will be deemed to have been lapsed. So, if in a lapse proceeding, section 24 will apply, he is entitled to get the compensation as per the provisions of the Act 30 of 2013. It's a pure question of law.
Yes.
Just satisfy why this question of law as raised by Mr. Banerjee will not be applicable.
My lord,
That is very as simple as
perhaps,
simple.
my lord, that is to be replied by the state.
Very good.
But no, my lord, kindly consider my submission. My lord, for a moment, kindly come to the page 26. My lord, actually,
Page 26 of the first date petition.
No, my lord, my opposition. My lord, what is the whether that
First
was
opposition of in the first
Yes,
date
sir.
petition.
Yes, sir. Yes. My lord, whether that was the land of the petitioner or that is the land of another, BSNL, my lord, not worried for that. BSNL is worried, my lord, they have to pay the compensation to the state government. And state government will be distributed to the, my lord, from whom the land was acquired. Page 56, my lord. My lord, unfortunately, my lord, those amount was not distributed to the petitioners or, my lord, where from the land was
What is
acquired.
page 56, sir?
Page 26, my lord. Page 26, paragraph of my opposition of my first writ petition 23317 of 2023. My lord, 5 times I have paid. Total amount, my lord, 6.
Sir, what can be done?
66 lakh 30,316. And my lord, then my lord, kindly come to the next page 43. Initially compensation amount for the entire land of 2.75 acre, 18 lakhs and odd, my lord. Kindly come to the page 43, my lord.
Page number?
Page 43, my lord.
Mr. Ghosh, you decide your dispute. Why Mr. Banerjee's client will suffer?
I am not, it is not also my submission, my lord, he will be suffered. My lord, it is also my submission, the state government ought to have paid the compensation. It is also my submission because that amount is already disbursed by the
So
PSL.
it is no more your liability, that's much. You contended that you have already paid compensation. It is because of the state government's negligence.
My lord,
So whatever compensation is payable, that is to be payable from the state government fund.
Yes,
That is
my
to
lord.
be
My another submission is, my lord, we have paid much more according to the demand of.
I understand your condition.
My lord, for a moment, kindly come to the page 43, my lord. What land acquired for the BSNL, my lord? That is the more than the land of the petitioner, my lord.
Sir, you decide amongst yourselves.
2.75. That land was, my lord, that is, my lord, certificate of possession of property made over Vidyut Kumar Mondal, JTO Tarakeshwar Telephone Exchange. My lord, certificate, I have this date 3rd September 1993. Your lordship got it that. And my lord, total land, total area measuring more or less 2.75. And my lord, kindly see one page, my lord, page 49. Page 49, my lord. My lord, that bold portion, thereafter the construction of large capacity automatic telephone exchange, construction of staff quarter at Tarakeshwar. Your lordship got it. Then, my lord, the land measuring more or less 2.7 acre, 2.75 acre, Then your lordship kindly come to the last total. That some figure is there, total 18 lakhs 49,991. So my lord, the total compensation for 2.75 acre was, according to the state government, calculated 18 lakhs 49,991, and we have paid, my lord, 66 lakhs and odd, my lord.
Why there is difference?
My lord, actually, my lord, due to the wrong advice, they are paying. They have not, my lord, turned out the page. What was the initial amount was to be paid and which was paid earlier. My lord, no, interest no, mean principal amount. Actually, my lord, that lastly, they have also issued one notice in second writ petition. That is the last, which is challenge. My lord, they have again asked for some payment, my lord.
So make payment. What can be done?
My lord, we have already paid. So my submission is this, my lord, the BSNL is already paid the sufficient amount that is more than.
Yes, madam.
And
What
my
you
lord,
got to
already,
say?
my lord, construction has been completed long back ago, my lord. Land was handed over in the year of 1993.
You are the advocate on record.
No, my lord.
Then
I'm appealing for the state.
you are the advocate on record for the state.
State
Make your
lordship.
submission. What is your good name, madam?
Kolpita Pal.
Sorry?
Kolpita Pal.
Kolpita. MS Pal. Yes.
Kindly give some time.
Take down.
Lordship.
What is that?
Lordship. It is in the case where there is no lapse under section 24(2).
Page. Yeah, you are an advocate on record.
Indo Development Act, Lordship, Indo Development Authority versus Manohar Lal and others judgment.
Madam,
Lordship.
tell me, you are the advocate on record for the state.
Lordship.
Mr. Dhod is the senior.
Lordship.
You have not come ready.
No, Lordship.
Very good. You will suffer. I will record that you have not come ready.
Lordship, kindly see the judgment.
Yes.
186.
I will see the judgment. Tell me why this court will not accept the contention of Mr. Banerjee that in view of the publication of notice under section 9B of the Amendment Act, the proceeding will not lapse. Simple as a question.
Lordship, if position is handed over, then there is no lapse.
The access so.
Lordship, Supreme Court judgment.
Access so. Show me the Indo Development Authority. Give me this judgment.
Lordship, kindly see. 186 and 187, Lordship, paragraph.
Give. Advocate on record, আপনি পড়াশোনা করে আসবেন না, আমাকে এখন সময় দিতে হবে।
Lordship, in the case where kindly see 1, 2, 3, 4, 5.
Page number?
Para
Paragraph number?
186, para 1, 2, 3.
Yes, read.
Kindly
Please.
see page number, line 6. Lapse of acquisition is provided only in the instances where possession has not been taken nor compensation has been paid in the proceeding for
Which portion?
paragraph 186, page 6, line 6.
Today I badly got stuck. I could not come in the morning.
Your advocate on record must come ready. Maybe you have been appointed as a senior. Why you are not? You are not advocate on record is not ready. He has been briefed. He draws bill from the government, from the office of the legal remembrancer. Maybe I have disbursed bill when I was legal remembrancer in favor of her. Very unfortunate state of affairs.
It has got a distinguishing feature. The case in hand and this Indo-Development Authority has decided so many other aspects. The interplay between Act 1 and implication of Section 24 of Act 2013. Previous view was if or has to be read either of these. Once the possession, second the payment of compensation. Now kindly in this matter, where the huge chunk of or huge tract of land was acquired by invoking Act 1, even then the Indo-Development Authority is saying no, the lapsing provision will not come into play because of few folks or land losers or the claimant did not receive the compensation. That will not be attracted. That was the factual aspect matrix of that Indo-Development, where Indo-Development has explained that once possession is taken and or has to be read as and, possession is taken and also the compensation is paid. Both the facts, if are missing, then lapsing will come into play. Here, the possession was taken. In our present scenario, possession was taken only what was intended by the state. The rest of the portion, there was an differences. They wanted, writ petitioner wanted that this remaining portion would be no use. Kindly, that should also be acquired. Then subsequently they came out from that stand because of the fact that we do not require, as the requiring body has said, no, we do not require that portion of land. So regarding that part, there was a condition given by the previous order that state is debarred from publication of an award because till state decides whether to go for it or not, that remaining portion, that decision was pending. Then, my lord, whether this embargo will come into play or not, that period when state authority was debarred to take a decision by the
But
Honorable High Court.
you went for eternal slumber. You did not do anything. You did not do anything. You didn't refer the matter to the civil court.
We did. But that was not required because of the fact my lord, we decided that we will not take that land. We will not acquire that land. Even Mr. Banerjee's client came out from that stand.
That is a subsequent stage, sir. That is subsequent stage. When Justice Lala passed an order, what steps you have taken for deferring under section 49?
I'm sorry.
After passing of the order by Justice Lala, what steps you have been taken for referring the dispute to the civil court?
Initially, we did not.
Yes.
Initially, we did not.
You never made any attempt to refer.
Subsequently, Mr. Banerjee's client came.
When? When you initiated a fresh proceeding.
No, perhaps not factually not correct. No, let me show.
Make your submission and make distinction. You will get a favorable order.
তারককরণ মামলায় আছে তার এফিডেভিট সে থাকবে না
3369 টা পাওয়ার পরে তো স্যার আমরা
Mr. Dhar, it is high time to take up the matter with the legal remembrance, sir.
In the matter where I am briefed, there is my learned friend is assisting me, and the other writ petition where I am not briefed, that Mr. Tarok Koron is learned counsel appearing on behalf of the state.
State will face the consequences. What can be done? I shall pass judgment today. No, Mr. Banerjee, don't mail him.
Kindly, I'll be relying on this Indo development few paragraphs.
Sir, Mr. Dhar, I will go to that. For your assistance, I am telling you the fact. Mr. Banerjee's contention was that from your communication, it would reveal that notice under section 93B was issued on 15/2/2001. So, under section 11 capital A of the Act 1, you are bound to pass award within 2 years, that is on 14/2/2023. No award was published. So, as per the provisions of section 11A, the proceeding lapsed. You failed to visualize that. You harped upon the order of the Justice Lala, and there you recorded that he is not willing to hand over the remaining portion. So you decided on your own way under Act 2 of 1948. That is your contention, Mr. It is this simple, as simple as I am telling you. So you now on such factual aspect, you just tell me how this reported decision is relevant. Matter ends.
Kindly come to page 350. Sorry, para 353 of that.
Indo development.
We are of the opinion that courts cannot.
Let me reach, sir. Let me reach. Page number 353 is that page number?
Para 353.
I'm sorry.
Page number 182. 182.
Yes.
We are of the opinion that courts cannot invalidate acquisitions which stood concluded. No claims in that regard can be entertained and agitated as they have not been revived. There has to be legal certainty where infrastructure has been created or has been developed partially and investments have been made, especially when land has been acquired long back.
It is the duty of the it is the duty of the court to preserve the legal certainty as observed in Vodafone International. That was.
So who is going to make it uncertain, Mr. Dhar? Who is going to make it uncertain? Mr. Banerjee is also not making such prayer. He is aggrieved with the quantum of the compensation, Mr. Dhar. No, this cannot be. Hey, asun, take down. This one has to be lovely.
compensation minus my lord the amount they have paid.
My lord,
They have paid
initially 1 lakh and one-
Yes, take down. Before parting with it is our, it is where will get that?
That is page 26. And my lord, we have given the check number, everything, my lord. And that is also admitted by the state. My lord,
Telegram
kindly-
বলুন তো। How the court will calculate that?
No, no. They will calculate within certain time. I was saying that.
No, all at a time, sir.
All at a time.
Again,
Very well.
not should be in a piecemeal manner.
As you
At the time of calculating the entire compensation, they will also calculate the rental compensation from the date of acquisition, from the date of possession to the date of initiation of the acquisition proceeding.
much obliged.
And my lord, we have already constructed the telephone exchange.
Hmm?
The BSNL is already, my lord, constructed telephone exchange with long back.
Sir, have I passed any order for dismantling? I have not passed any order for return of the land by dismantling. Then how we are aggrieved, sir? No, I will not pass any single line. Call the next matter. হ্যাঁ, with the aforementioned ওই দিয়ে দেবেন, কমিউনিকেট করার অর্ডার দিয়ে দেবেন, করবেন with the aforementioned observation WP এর, হ্যাঁ, রেসপন্স টুকে করো। তুমি আগে একটা ওই M10
35. I'm for the petitioner.
WBSCDCL.
WBSCDCL, disciplinary proceeding culminating into a final order of punishment and the order of the appellate authority. Both are under challenge before your lordship.
But I am filing opposition.
Since this matter is going on, why not we have got three matters.
I beg your pardon, sir?
We have got three matters from the same parties. Can it be given on Thursday? 30.
Arising out of the same transaction?
Huh?
No.
No.
Yes, subsequent matters.
Subsequent.
Adjournment till next Thursday.
What do you want, sir?
It should be adjourned till to.
Oh, you are seeking not today.
36.
Yes.
You are seeking not today.
On Thursday, I am telling you. I appear for the petitioner item number
36, 37, and 38.
Yes, 36.
What do you want?
Thursday is little bit. I do not stand in the way. I appear for the petitioner.
36, 37, 38 Thursday means হচ্ছে কত তারিখ? 28 আগস্ট। কিছু আছে? কতগুলো 2 PM আছে? Fixed matter আছে।
Then my lord will come back tomorrow. It's my petition. These matters.
Otherwise, it will be very difficult.
Yes. I want to. But tomorrow
Let it remain as it is. I'm adjourning. I'm making it not today only.
Tomorrow I've got some problem. That's why I'm telling. Day after tomorrow.
Day after tomorrow কি অবস্থা? বুধবারে? So then next week, sir. Not
I am
possible.
the petitioner, my lord.
Then you decide. Otherwise, it will. I shall pass. No order.
My lord, let it remain. My lord should
Very good. It will remain, sir. If you have got difficulty, ask any of your friends. I shall
That's
answer.
sure.
It's very difficult to accommodate each and every person. এই দেখি ওরা কি আছে দেখি। এটা আবার ডিসিপ্লিনারি সার্ভিস ম্যাটার।
একটা রিয়াফার্ম কপি দিয়ে দিই, একই সেম কিছু চেঞ্জ
বিভিন্ন পর্যন্ত আগে একটা ছিল না, এটা অ্যাপ্লিকেশনে। এটা কি ক্যান নাকি?
হতে পারে।
What was the penalty?
Penalty or termination from service without any benefit. Period of suspension is also No benefit out of that period.
What are the charges against you?
Charges, my lord. The charge sheet is at page 64. I'm just giving short background. He was not posted as the divisional engineer of WBACDCL and posted at Bankura. Now, a complaint was made by one consumer directly to the vigilance cell, not to my superior, but to the vigilance cell, that I have said that I will charge him bills of 10 to 12 lakhs unless he gives me illegal gratification of 2 lakhs. No bill was produced or no bill was there. Said that he complained that I have demanded 2 lakhs, otherwise I will charge a bill of 10 to 12 lakhs. This is the allegation, on the basis of which complaint was made to the vigilance cell and a trap program was organized. Trap program. Now, I didn't have any quarter. I was staying in a hotel, a lodge. One room was hired. In that room, I was staying. In that room, the trap persons, the vigilance department, they came, and from the bed, they say that they have retrieved a sum of rupees 21,000.
Coloring test was done?
No, phenolphthalein test was not done. That is one of my points. That unless, because it is not my home. This is one of the points, not one of the points. It is not my home. So you are not getting it from my home or in my possession. It was kept in the room.
Mr. Banerjee, this is not a case of prevention of corruption.
No. PC Act proceeding was initiated. Proceeding was initiated where I was honorably discharged. And this was one of the findings of the court, that why didn't you do phenolphthalein test? If you are pinning down somebody, you're not going to his home, some third place, you are holding him guilty, then whether he at all had the money taken from the complainant or not, that is to be proved. For that, phenolphthalein test is must. That was not done. Not done, and so anybody could have not planted the money there. Anyway, they initiated the proceeding. Criminal proceeding was initiated. I was suspended. Charge sheet was issued. Now, after the punishment, in 2024, ultimately I have been honorably acquitted, saying that they have failed to prove the charges under the Prevention of Corruption.
By the special court.
By this special court. I'll just file a supplementary affidavit enclosing that judgment. Now, the first point is that, my lord, reply, my lord, they have been the opposition, the reply, my lord, to their. It is additional sessions judge, special court, third court at Bankura. The court where not the Prevention of Corruption Act proceeding went on and ultimately discharged.
So it was a case under the PC Act, Prevention of Corruption Act.
I'll place the charge sheet. I'm just giving the nutshell of what are the facts I want to ask before your lordship. So first point is that the complainant, the person who has written the complaint, he never appeared before the disciplinary authority to prove his complaint. Other persons on the trap program, they were present. They have given their evidence, but the complainant himself was not present.
Complainant means the customer.
Customer. Now, the bill, what he said that a bill of 10 to 12 lakhs shall be charged, there was no such bill produced because it said it's a verbal submission. So it becomes again not hearsay because complainant has written, but he has not appeared and proved that. So the complaint is not proved. I don't get a chance, my lord, to cross-examine the complainant. And the bill on the basis of which the complainant has lost the complaint, that was imaginary bill because no bill actually is there that 10 to 12 lakh has been charged. This is the background fact on which, my lord, the proceeding continued.
Same set of evidence was adduced.
Same set of evidence because of the persons who were, my lord,
who were the prosecution witness before the special court. They were the witness in the
same person.
Same person.
The complainant will not appear there in the proceeding.
Very good. Apart from
he has not appeared here.
Apart from the complainant,
the other witnesses
are same.
Almost same. Most of them are same. I'll just point out.
Those are
very vital.
Those are very vital.
Because on the basis of their evidence has been disbelieved by the court, saying honorable acquittal. So I'll just give a list. I'll prepare a list and
kindly check whether same set of evidence has been adduced or not. If it be same set of evidence, it will be in your favor. Otherwise, it will not be in your favor. Mr. Kole?
Lord, against this acquittal order, We have already, my lord, that
Prepare an appeal.
instruction, prepare an appeal. That's my instructions. And moreover, my lord, this acquittal order has been passed after completion of the disciplinary proceedings and order passed by the appellate authority.
Let
Yes.
Mr. Banerjee answer.
Client's instruction is that the witnesses in both proceedings are same. Except
No,
my lord-
instruction will not suffice.
I'll give the
You have to
particulars.
certify.
I'll certify. I'll give the documents not to show.
Yes.
Because the criminal proceeding is there from the DP. I can show. Except my lord, one person who is the my lord complainant. He is one owner of my lord one cold storage who lost the complaint.
Mr. Banerjee, if the complainant does not appear,
That is better for me.
better for you.
Better for us. There he appeared, but here he has not appeared at all, which is one of the main points that unless the complaint is proved, because basically it's demand and acceptance. There has to be some demand, acceptance. Nothing is proved. Only the money. Only thing proved is that some money was lying in that room. Now, who has planted that? That we don't know. They say that it was there. They have found it under my bed. A sum of 21,000. Allegation is of 2 lakhs, 21,000. Notes were signed by the vigilance team, but no finaphthaline test to show that I am the person who has actually received the money.
The numbers of the currency notes matched with the previous those prepared by the team.
Yes, because in the criminal proceeding, court has recorded that, but said that total scanning the total evidence, court has said that without finaphthaline test and without showing the entire chain of events to establish that I have received the money, the entire case falls apart. That is the finding of the criminal court. I'll go to that, but before that,
Different, sir.
that is a subsequent event also. But my lord, the fact remains that this proceeding is vitiated basically for absence of the complainant and not the charges which are leveled. All the charges are not proved. I'll establish. Kindly allow me to place the charge sheet, my lord. Charge sheet is at page 64.
64 of the writ petition, sir.
Of the writ petition. But you will kindly keep the first page, my lord. Kindly come to the second page. 65.
Yes.
Now, Lord, may I place note the charges? Whereas it appears that Sri Gopal Chandra Niyogi, was posted at Bakura Circle as divisional engineer since 2012-99 to 4/1/2003, the date of suspension, and it was his duty to take meter reading in respect of centralized, decentralized bulk consumers under the jurisdiction of Bakura Circle and other allied jobs as per instruction of the superintending engineer. And whereas it appears that one bulk connection was exists in the name of Messrs. GM Cold Storage Private Limited of Kotolpur, and whereas it appears from the allegation dated 26/12/2002 of Sri Dinobandhu Gorai, Managing Director of GM Cold Storage Private Limited, that Sri Gopal Chandra Niyogi, divisional engineer, had been threatening him that a large amount of bill to the tune of rupees 10 to 12 lakhs would be claimed against said GM Cold Storage Private Limited due to some faults in the metering system. It also appears that Sri Niyogi, divisional manager, demanded bribe of rupees 2 lakhs from Sri Dinobandhu Gorai for non-claiming of such large energy bill against his cold storage. And whereas it appears from the above allegation of Sri Gorai that Sri Dinobandhu Gorai, having been afraid from the onslaught of the above threat from Sri Gopal Niyogi, divisional engineer, Sri Gorai was compelled to pay a sum of rupees 70,000 on 3 occasions as bribe to Sri Niyogi, divisional engineer. And whereas it appears that in spite of payment of 70,000 by Sri Gorai, Sri Niyogi went on threatening and demanding the balance amount of 1.30 lakhs from Sri Gorai. Hence, finding no other way out, Sri Gorai came forward with the aforementioned allegation against Sri Gopal Chandra Niyogi, divisional manager, to the corporate vigilance cell of the board seeking redressal. He goes directly to the vigilance cell.
So what is the harm?
No harm. There is a reason, my lord, why I am saying this. Because my specific allegation was that, my lord, my immediate superior, who was this, my lord, superintending engineer, my lord, he, my lord, had directed me, my lord, to do something to which I did not, my lord, accede. He is, my lord, instrumental to the entire thing.
he although
That is your defense.
and the criminal court might also has taken note of that fact. There's finding also that this person who is present everywhere, he was not cited as a witness, didn't sign anywhere, but he was instrumental behind everything. During the raid, he was present. He took this person by cart to the vigilance cell, as per Cross and Chief Millard. He took that Mr. Gorai. This is not the job of the superintending engineer to take a complainant to the vigilance cell or to take to the particular uh, uh, place where the raid is made. He goes everywhere, but his name is nowhere to be found because he was that is the allegation, and the criminal court also has taken note of that. Then Millard.
My lord, just I'm sorry. My lamentation is, my lord, banking upon more than the, my lord, criminal court judgment. That has not been taken into consider by the appellate authority, not there.
Naturally, it could not have
Actually, that has been passed subsequently. So if, my lord, my lamentation is banking upon the criminal court's order, he should have been referred to the appellate authority for consideration.
Mr. Banerjee is well aware as to why, when a finding of a criminal proceeding operates favorably in favor of the delinquent, he knows better
yes,
than us.
That
At least me. At least.
That I know.
The standard of proof is different. The general defense would come.
Neither is it. Place the charge.
Whereas it appears that the board authority on receipt of the allegation against Sri Niyogi laid a secret trap towards apprehending Sri Niyogi and to catch him red-handed while taking the bribe. And whereas it appears on 4/1/2003, the board's vigilance officials, with the help of Deputy SP Bankura, the executive magistrate and others, had been at Sudha Lodge, Rampur, district Bankura, to work out the secret trap. Whereas it appears that in the aforementioned secret trap, Sri Gopal Chandra Niyogi was caught red-handed by DSP Bankura in presence of the executive magistrate and the vigilance officials of WBSEB while accepting bribe of rupees 20. Kindly marks this. While accepting, they say while accepting, but the facts or the evidence is completely different. Accepting bribe of rupees 21,000 from Sri Dinobandhu Gorai. It further appears that the police officials instantly seized the bribe money of 21,000, comprising 2 numbers of pre-signed 500 rupee Indian currency notes and 200 number of pre-signed 100 rupee note of Indian currency, duly signed by Sri Sandeep Datta, WBCS Executive Magistrate, Sri Dulal Chandra Pal, Sri Dinobandhu Gorai, from the personal possession of Sri Gopal Chandra Niyogi, divisional engineer at Sudha Lodge, and later Sri Niyogi was arrested by the Bankura PS and a police case was started against him. Therefore, it appears that Sri Gopal Chandra Niyogi, deputy divisional engineer, intentionally and unnecessarily harassed Sri Dinobandhu Gorai, MD of GM Cold Storage, a bulk consumer, demanded and accepted illegal gratification from Sri Gorai for his personal gain, and also tarnish the image of the board in the eyes of the public. Such conduct of Sri Niyogi, divisional engineer, if proved, is unbecoming on the part of the employee of the board and is in violation of the regulation 38 and 59 of WBSEB ESR and tantamount to act of misconduct in terms of regulation 61D, E and P of the employee service regulation. So these are the allegations, my lord. Now, my lord, so the allegation is that demand and acceptance of bribe, that is the main allegation, and the resultant is the image of the corporation is tarnished.
Naturally.
So, my lord, for proving the demand, my lord, the complainant who says that he has demanded from me, his presence is mandatory, because if he is not there and I don't get to cross-examine him, then the demand is never proved. Other ancillary things which are proved is that there was money in that particular room. Now they have said that they have seen me accepting from Dinobandhu Gorai. I'll proceed further how this particular allegation is proved. So this is the charge sheet. Now the inquiry report is at page 196.
Only 96 or 196?
196.
page 3 of that order, my lord.
Give me a second. Yes, 196 is the inquiry report.
196 is start note. 198 onwards, kindly allow me to place some portions, my lord.
Yes.
The point for determination is whether
198.
198.
Yes.
In third internal. The point for determination is whether the charges against the Nyogi have been proved beyond any reasonable doubt. 10 witnesses have been examined for the prosecution. 4 witnesses, including the charged officer himself, have been examined as defense witness. PW1 is the senior manager, P&A, who was attached to the corporate vigilance cell during the period 96 to 2003.
এখানে সেখানে আপনারা পেন লাগান দেখুন এখানে একটা পেন পেজটা তুলতে গিয়ে এখন আমরা যে করেন না আপনারা
Accepting against the charge.
এখানে সেখানে স্টেপল লাগালে তো খুব চাপ এই দেখুন নেই তো মরছে পড়া পেন আর সাবধান কি যা হওয়ার তো বলেই এই তো এখন থাক হবে আমি লাগাচ্ছি মরছে পড়া পিন হয়ে গেল
tomorrow 2 p.m.
Yes, tomorrow 2 p.m. Heard Mr. Banerjee, learned advocate, appearing on behalf of the petition at length. Let the matter be listed today, tomorrow. Data দিয়ে দেবেন under the heading part matter with the mark 2 p.m. এটা প্রথমে নেওয়া হবে
Reply be.
Oh, sorry. The affidavit, প্রথমটা লাইনটা লিখে নেবেন তো প্রথমে the affidavit in opposition as filed on behalf of the WBSCDCL and the affidavit in reply thereto as filed by the petitioner are taken on record. বাকিটা এটা করে